Thank you very, very much. I declare open this hearing of the Parliamentary Joint Committee on Corporations and Financial Services into the oversight of ASIC, the Takeovers panel, and the corporations legislation. I begin today by acknowledging the Ngunnawal and Ngambri people, the traditional custodians of the land on which we meet, and I pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing in person and via video conference. These are public proceedings being streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request the answer be given in camera. I remind any committee members and witnesses who are appearing via video conference to mute their microphones when they are not speaking. I also want to note for the public record that it is the last occasion on which this committee will oversight ASIC under its current leadership, Chair Mr Joseph Longo, who has served at a very, very high level in our country with distinction and with great care, and very responsive to the requests of this committee. I would have to say that in the time that you've been chairing, the briefs that we've received and the level of communication has really escalated, and that allows us to do a better job in terms of putting perspectives to you from the Australian public when you appear before us. So on behalf of the committee and others, can I sincerely thank you, Mr Longo, for your service of the public good. And I now invite you to make a slightly longer than usual closing statement.
Just before that,
Mr Senator Scarr.
Make some comments as perhaps with yourself in terms of committee members here today. One of the longest serving members of this committee, albeit I had a small interregnum. It's very small. I just want to associate myself with your remarks, Chair. I think, Chair Longo, you've done an outstanding job. At the outset, I commented on the distinguished professional career you had that formed the foundation for your service for ASIC and for the Australian people. I think this must be one of the most complicated leadership jobs in terms of Commonwealth agencies in this country. I think you've achieved a wonderful balance between the competing priorities. You've always been deeply respectful of the questions asked by the committee, and more than anything, from my perspective, you've shown a passion. You've shown a passion to protect the Australian people from egregious corporate behaviour, and I've really admired that. And I think you've made a profound difference. So thank you very much.
Yeah. Well said. Over to you, Mr Longo.
A wonderful way to start the day.
It's all downhill from here.
Well, we'll do what we can to make sure it's a very productive day, as it usually is. So can I say good morning to everyone? And yes, it is my last appearance before this committee after 5 years as ASIC's chair. And as the chair noted at the very beginning, I do appreciate the indulgence that's been given me to speak for a couple of extra minutes, but I do reassure the committee it won't be that much longer than usual. I'm joined by Deputy Chair and incoming Chair Sarah Court, Commissioners Alan Kirkland, Kate O'Rourke and Simone Constant around me, Scott Gregson at the end of the table, and of course Chris Savundra, our Executive Director Enforcement and Compliance. Today I want to offer some observations about the organisation I've led since 2021 and the opportunities and challenges I see on the horizon. Before I begin, I would like to acknowledge the essential role the members of this committee perform within the parliamentary system. ASIC is the only financial regulator in the country with its own statutory oversight committee, in recognition of the deep complexity of the legislation that we administer and its importance to the economy. This committee has been sitting since January 1991, when the Australian Securities Commission, ASC, as it was then known, now ASIC, was created. And since 2002 alone, this committee has undertaken an extraordinary 98 inquiries and reports, approximately 4 a year, examining a range of important issues to Australians. Appearing before you today concludes my term almost where it began, although I think we can agree much has changed since then. In my first remarks to this committee, I said that I believed that ASIC's strength and effectiveness as an institution can and will be enhanced. And if I may say so, indeed it has. And today ASIC is a modern, confident and ambitious regulator. Modern because we prioritise data and technology to keep pace with the fast-changing financial system. Confident because we are prepared to act decisively, publicly and proactively to address misconduct and emerging risks. And ambitious because we're willing to raise the bar for ourselves and for the financial systems that Australians rely on by testing the law and driving systemic change through every available channel. You can see evidence of that ambition in the breadth and depth of the matters we pursue, whether that is securing $250 million in combined civil penalties from ANZ for widespread misconduct and systemic risk failures, pursuing Australian Super and CBUS for devastating member service failures, obtaining a $26 million fine just this week against Westpac for hardship failures, or holding the ASIC to account for serious governance and operational failures, a topic I know this committee has continuously looked at the last 5 years. Ambition is why ASIC is in court nearly every day of the week, from the magistrates' courts all the way to the High Court. And indeed, as we speak, we are awaiting a decision from the High Court on a digital asset matter. During the past 5 years, we've more than doubled the number of formal investigations each year, and we've quadrupled the value of penalties obtained. This financial year, we've already secured approximately $484 million in penalties. Now, I pause there. That's nearly $500 million, and this in this financial year alone, not including those still subject to court approval. That is an extraordinary change from the situation 5 or 6 years ago, although I have to say that the change in the law helped in 2019-2020. So ASIC today is undoubtedly stronger and more effective than it was 5 years ago. And I also want to acknowledge here the important role of the Financial Regulatory Assessment Authority, FRA, in assessing and reporting on the effectiveness and capability of ASIC. In FRA's first review of ASIC in 2022, FRA found ASIC was a generally effective and capable regulator. Turning now to the challenges and opportunities ahead for ASIC. First, we need to maintain trust in our institutions, such as ASIC. We can't have open, robust and competitive markets without confidence and trust in the integrity and resilience of our financial system. ASIC plays a critical role in delivering this outcome. Confidence and trust depends on people seeing ASIC boldly enforce the rules and follow through on our commitments. One of the significant decisions that Sarah Court and I took early on in our terms was to institute a yearly practice of announcing ASIC's enforcement priorities. These make clear the choices we make in prioritising cases and deploying our limited resources, and holds us accountable for doing what we said we would do. Being an effective regulator means making difficult choices, and that includes choices about what we investigate and what we litigate. ASIC does not have unlimited resources, and litigation is costly, particularly when taking on the big end of town, seeking to hold multiple office holders to account or addressing industrial-scale misconduct, as ASIC has done over the past few years. This brings me to a second challenge, the sustainability of the Enforcement Special Account, known as ESA. ASIC's strong enforcement outcomes, increasing complexity of matters, and government savings measures have significantly eroded the cash balance of this special account, designed to provide capacity for significant matters. By 30 June this year, the ESA is forecast to fall to the minimum level needed to manage the risk of adverse court orders. Absent replenishment, this will impede ASIC's ability to maintain its current enforcement program. We are engaging with Treasury and Government about this. Of course, ASIC doesn't operate in a vacuum. Effective enforcement relies on the broader system around us. We strongly support the Federal Court's expanded criminal jurisdiction, which allows ASIC to bring civil and criminal matters before a single specialist court. But capability must be matched by capacity, with capacity. Frankly, we cannot expect ASIC to run more and more timely criminal cases if the Commonwealth Director of Public Prosecution's resource envelope to assess and determine ASIC's referrals of briefs of evidence remains static. This is particularly so as the demands on the DPP grow from other law enforcement agencies around the Commonwealth. The third challenge ahead is continuing to get the balance right between active enforcement and regulation. With the remit spanning millions of entities and individuals, ASIC faces a stark reality. We simply cannot litigate our way out of every problem. Litigation by its very nature is a rear-view mirror. It cannot deal with many of the forward-looking challenges we face as a nation. Challenges such as improving our national productivity, encouraging innovation, increasing financial literacy, and maximising the opportunities presented by technologies such as AI and supercomputing. This requires ASIC's regulatory strategy to be informed by imagination, ambition, and collaboration among all stakeholders. This approach is reflected in ASIC's implementation of several major reforms since 2021, including climate disclosure, digital assets and crypto in particular, the banking code, and developing a roadmap for our public and private markets, and also improvements in how we deal with scams, among many examples. It's why ASIC is internationally active and engaged, not just with other regulators, but with the global players who are doing business in Australia and contributing to Australia's reputation for being an attractive place to invest. It's also why we are encouraging financial innovation, from being a key part of the Reserve Bank's Project Acacia to exploring ways we can better support startups with pathways from regulatory sandbox to licensing. And it's why we've initiated a national discussion about regulatory complexity and acted to address it through our ASIC Simplification Consultative Group. We've long struggled as a system to deliver timely and meaningful law reform in corporate law and financial services. At ASIC, I am continually hearing that regulatory burden and compliance costs are simply too high and climbing. It's high time we did something about it. As part of the national conversation about productivity, we need to consider how the public and private sector can better work together to more effectively reduce the compliance burden. ASIC's public and private markets work is a good case study, in my view, on how difficult and complex problems can be addressed through a structured and transparent collaboration between the public and private sectors. Since the Corporations and Markets Advisory Committee, or CAMAC, was defunded in 2014 and subsequently abolished, a public-private mechanism to consider and recommend legislative reform has not existed in relation to corporations and financial services law. And I think it's fair to say that the market and the general community misses it. In my view, a modern, updated version of CAMAC would be most welcome, and perhaps a broader, more ambitious version of ASIC Simplification Consultative Group, which includes representatives from business, consumer groups, Treasury and academia, could form a template for such an initiative. The fourth challenge, and perhaps the most urgent, is the need to stay ahead of technological change. Notably, FRA highlighted, Financial Regulatory Assessment Authority, in its 2022 review, the urgent need for further investment in technology and data for ASIC to remain, and I quote, effective, credible and relevant into the future. This is a call I and the Commissioners have certainly heeded, and I've certainly heeded it as Chair, because the pace of change is accelerating. The period between discovery and disruption is compressing. If we do not remain institutionally engaged and curious about emerging technologies and innovation, it will be an existential risk to ASIC's effectiveness and credibility as a regulator. We already know that regulators such as AI will directly challenge our regulatory capability. We must rise to meet that challenge. That means we need at least three things. Information when it matters. the powers to audit and test where and when it matters, and the ability to give the market clear signals about our posture and why it matters. We ourselves must also embrace these technologies and use them for our own purposes. In other words, the forces reshaping our markets must become part of how we regulate them in future. We are fast approaching a future where fit-for-purpose regulation is data-led, responds in real time, and anticipates problems before they escalate, backed, of course, by strategic and timely litigation. If we miss the boat here, we risk becoming irrelevant. ASIC is celebrating 35 years of operation this year. However, we cannot regulate the future with tools of the past. That's why we are piloting access to advanced supercomputing infrastructure in partnership with the University of Technology of Sydney's Human Technology Institute and the Pawsey Supercomputing Research Centre in Perth to test how predictive, probabilistic methods can support earlier detection of conduct harms and more targeted supervision. I welcome the government's recent investments in ASIC to strengthen some of our digital capabilities. This includes $97.3 million investment to complete Registry Connect Tranche 2, delivering new services, linking director IDs and modernising and securing our registry systems. The fifth and final challenge is supporting consumers and investors to make confident and informed financial choices. We welcome the government's $10.3 million investment to strengthen oversight of the managed investment scheme sector, enhancing ASIC's digital capability and access to non-ASIC government data, as well as the investment of an additional $6.2 million over 4 years, with $1.4 million ongoing to improve governance arrangements and further strengthen supervision of the sector. This will better position ASIC to respond to existing and emerging risks, including those highlighted by the Shield and First Guardian matters. However, I want to be frank that this is not a silver bullet. Investors and consumers will continue to sustain losses from time to time. The possibility of losses lies at the heart of investment risk-taking, and our system of regulation encourages risk-taking. ASIC cannot, nor is it our role, to always be in a position to pick up the pieces. Prevention is always better than cure. We must continue to invest in initiatives that will empower consumers and investors to make good decisions in their own interests. Investing in financial literacy and in ASIC Money Smart is fundamental to this. I will end with a thank you to all of ASIC's talented and dedicated people who are working very hard every day to ensure Australians benefit from a fair, strong and effective financial system. I thank you, Chair, for giving me a little bit more extra time, and we now welcome the committee's questions and engagement.
Thank you very much indeed, Mr Longo, and I'm sure that your statement will be much reported. There's a lot in there. Can I just go back to the official words and indicate that I understand that information on parliamentary privilege and protection of witnesses giving evidence to Senate committees has been provided to you all? For the Hansard record, will you please state your full names and capacities in which you appear today? We might start down the end with you, Mr Savundra.
Chris Savundra, Executive Director of ASIC's Enforcement and Compliance Team.
Kate O'Rourke, Commissioner.
Sarah Court, Deputy Chair.
Joe Longo, Chair.
Simone Constant, Commissioner.
Alan Kirkland, Commissioner.
And Scott Gregson, Chief Executive Officer.
Might take the opportunity also to allow my colleagues to introduce themselves and put that on the record. We might start with you, Senator Scarr.
Senator Scarr, Senator from Queensland.
Honourable Scotty Buchholz from Queensland.
This is your first oversight of ASIC. Welcome.
Thank you.
Historic.
I was a former chair of the Economics Committee, so we used to have a line of sight to ASIC, APRA, ASIC, ACCC, ASX. So, yeah, looking forward to engaging.
Thanks.
Thanks.
You for joining us. Deborah O'Neill, Senator for New South Wales, Chair of the Committee.
Madonna Jarrett, Member for Brisbane. Senator Ellie Whittaker from Western Australia.
David Moncrief, MP, Member for Hughes in Southern Sydney.
And I believe joining us by teleconference we have Miss Tanya Lawrence. Are you there, Miss Lawrence?
Thank you. Yes, thanks very much and good morning. And my apologies I couldn't be there in person, particularly on this occasion, Chair Longo.
And the reason that you're not with us is because you are somewhere else in the country, because you're the member for?
Councillor from Western Australia, my apologies. Thank you.
Thank you very much. Excellent. Chair Longo, I note that the ASIC enforcement priorities for 26 were extensive, and many of those you have provided quite a detailed response to in the submission that we will be interrogating today. But amongst those matters that you indicated were going to be an enforcement priority for 2026 was the strengthening investigation and prosecution of insider trading conduct, but also auditor misconduct. And that brings me to some pretty contemporaneous concerns about the quality of audit. And it's not a new area. We've traversed we've ploughed this field a few times. And I have to say that I don't like the look of what's growing in the field, Mr. Longo, and I'm sure you don't either. So if I can commence with a series of questions and then I'll share the call with colleagues. I want to take you through a hypothetical situation because there's a lot of matters that are live. But if I can commence with the fact that as prescribed under the corporations legislation, companies are required to provide full access to all sensitive documents when an auditor arrives. Is that correct?
We anticipated this interest, Chair, so if it's okay with the Chair, I'm going to ask Commissioner O'Rourke, who's done an immense amount of work in this area, to answer these questions. Start with that question and we'll take it from there, if that's okay.
Great, thank you. So I've got a number, so we don't want to go too long, but I definitely want to get on the record so people who don't follow this but need financial literacy to understand what's going on, get the lay of the land. So when an auditor arrives at a hypothetical company A, B, C, D, at partnership, A, B, C, D, were to go to an external auditor or firm, we'll call that firm Take Transfer, they have prescribed capacities, and that is an entitlement to full access to all sensitive documents. Is that correct?
Thank you. So we have had opportunities to discuss auditors and their role with respect to companies before. So I think I'd respond by saying that they've got a particular role, the auditors, in relation to the verification and assurance of financial information. And so I'd say that their access requirements, there may be some boundaries there that if there's, I think, sensitive information or confidential information that are entirely unrelated to that, I'm not sure that they would get access to that, but the general principle of having unfettered access to anything in relation to the financial work assurance that they're doing, I think that's the heart of your question.
Okay.
Yes.
And that phrase, unfettered access, is really what the perception is, that an auditor would arrive and people go, okay, they're going to ask for anything, we need to be ready to hand over everything related to the financial documents.
Yes, I think that in order for the auditor to complete the work that we as a system expect of them in providing that verification and assurance, their capacity to have access to the information they need to do that is wide. Okay, so having established that, let me just say that in this hypothetical scenario, Partnership ABCD are an external auditor for firm Take Transfer. That's what we'll call them. Take Transfer had one point decided to go to audit tender, but ultimately stayed with ABCD as other audit firms were viewed as unethical. Now, Partnership ABCD then used its access to audit documents to steal data on rival bids, potentially including things such as pricing, resource allocation and skills. Partnership ABCD then uses this privileged information on rivals to inform their own audit tenders for other firms. In that scenario, Ms O'Rourke, what laws could have been broken by that partnership, that audit partnership ABCD? Thank you for your question and for setting out the issues as a hypothetical. I think in circumstances of a hypothetical it can be difficult to be conclusive about particular provisions that might apply or indeed might have been broken because of the wider circumstances and the different evidentiary points and other things that might be required.
Exactly. So we're doing first principles here. Like, how does this work? So people people who don't engage with this sector very much, I want them to understand that's what we're here to make sure there's communication with the Australian public in a way that they understand.
And I think part of my hesitation is that we're able to assist with more precision in relation to provisions that go to the preparation and completion of an audit. And so there may be information sharing or other aspects of the hypothetical that you've put that are under provisions or under wider, whether it be contractual or other ones that may also be enlivened, and that ASIC might be not as helpful in relation to.
So let me just break it down a little bit so we can get some clarity around this. So if partnership ABCD goes in and steals data on a rival bid, what laws could they have broken by undertaking that action?
So I think that in order to give you an accurate and complete answer, I'm going to have to take some time to think about that and come back to you. I'm sorry, Senator. Like I said, I can speak to what aspects of it are regulated and complied with respect to actions as an auditor, but I think that wider question around are there other laws that may have been broken?
I'm really only interested in the auditing laws, right? So the bits that you guys are aware of, not other, espionage type things. So if ABCD goes in and gets data about pricing on a rival, is that okay, or is it not okay? And so what have they breached in doing so?
Yeah, so no, the provisions that govern how an auditor is registered and then conducts the audit, I don't know if they speak directly to provision of confidentiality. They're cast more widely around their professional behaviours and the audit quality provisions that apply. So I think if your question
sounds way too ambiguous. I mean, I'm sitting here and thinking about an Australian person who says they went in, they took information about pricing. It's either right or it's wrong. It's either enabled or it's not enabled.
Yeah, no, thank you. I think
I'll have a try, Senator. Just
pricing, resource allocation skills.
Yeah, and understand the context for the hypothetical, and with all the reservations about hypotheticals that no doubt you'll indulge us with. I think, as we've discussed at this committee many times before, in relation to the work that ASIC particularly does, we deal with registered company auditors, not the conduct of the firms themselves, and we've talked a lot about is that a gap in the law, and I think we've been in heated agreement that we think it is. In the scenario that you are contemplating, it occurs to me, and Mr Savundra may have some additional views, there's a range of laws that may be broken there. They may be criminal laws, and indeed we know that there's been a criminal investigation in relation to a similar fact scenario that we've talked about at this committee before. There may be competition laws that are broken if you're stealing sensitive pricing information and using that information to your advantage. Of course, there's professional conduct obligations that, again, we've talked about at this committee, and there may well be laws under the Corporations Act that we could find out about. So I think what we're saying is, while hypotheticals are difficult to speculate on, in the circumstances that you outlined, there are a range of potential laws, both criminal, potentially competition, potentially under our Corporations Act, and potentially, obviously, professional conduct laws.
If we can go to the professional conduct laws, over which you do have a significant oversight, and let's particularly talk about one of our favourites, APES 110. There's the sort of behaviour of accessing audit documents to steal data on rivals' bids, including potentially pricing, resource allocation and skills. Would that be the sort of behaviour that would draw negative attention? Is it a reproachable act, or is it common practice for these things to occur?
Well, again, Senator, Ms O'Rourke will be better placed on the details of that particular set of obligations. But at a high level, I think we would completely agree with you that to steal information and use it to your commercial advantage would raise a range of issues, both professional and potentially other laws. Now, which particular provisions that would fall under, we would have to look at the particular facts, but it's certainly something that I don't think anyone could quibble with. The scenario that you're placing raises a whole range of very significant issues.
Thank you very much. Mr Savundra.
Chair, if I could, and just to clarify, so the lead auditor would have an obligation under the auditing standards, and those auditing standards extend, as you've mentioned, to APES 110. So we're talking here about the individual registered auditor rather than the audit firm.
And that was to be my next question. So well anticipated, Mr Savundra. Would ASIC be able to take broader actions against partnership ABCD or just the auditor or auditors directly involved?
Yeah, so that is an area we've discussed before, and I think we've provided information that our regulatory provisions apply to the audited, the registered company auditors, and not to the firms.
Okay. Thank you very much. So I think that sets the ground, and I think it reflects general community understanding at this point of time. Now, during the last hearing of ASIC Oversight, the committee spent some time considering KPMG's audits of Star Casino. It was here that Mr Savundra stated, to the extent they're operating as an external auditor, they're under statutory obligation to report misconduct to us. That falls within our jurisdiction. Can you please articulate how auditors' actions and ethical behaviour fall within ASIC's jurisdiction?
You'd like some more information about the reporting, reporting
perhaps
obligation?
Mr Savundra might be able to respond, seeing as it was his statement first, and we'll come back to you, Ms O'Rourke.
Okay.
So there's a statutory obligation for a registered auditor to report misconduct to ASIC. I'll see if I can get more specifically the obligation. So it's contraventions of or suspected contraventions of the Corporations Act, attempts to unduly influence, coerce, manipulate or mislead a person involved in the conduct of an audit, or interference with the proper conduct of an audit.
So that's very specific, and you can get to that when you're at that point that you're advancing. But one of the key things was to mislead. And I guess deception in any form across any role within the audit sector is probably not a good thing to be engaging in, and certainly at odds with APES 110. Ms O'Rourke, did you want to add anything?
Oh no, I think that answers the specific question of the reporting obligation, unless there was additional information in relation to that would assist.
Okay, at this point of time, I'd like to table a public letter. I'm sure you're probably aware of this already, but just for people to be able to read it. It's from Lend-Lease to this committee. Do you have a copy of that letter with you? Because I've got copies here.
I don't.
We don't.
All right, well, it's coming to you now. And I'll wait for those to arrive with you so I can just work through the document.
Yeah.
Thank you.
So, and can I be clear that in any of the questions that I'm asking you, I'm going only to things that are now in the public place, having been received by the committee in our formal processes. As you can see, there is the copy of the letter from this committee to Mr Lombardo, the Chief Executive Officer and Managing Director of Lend-Lease, which is a rather large company. In fact, as we drive down here from the Parliament, it's lit up every night with about 6 major cranes there. So this is no small fly-by-night, beginning to be established business. It's a long, sophisticated, signature business, I guess, in our development sector. Following that is Mr Lombardo's response to our question. Can I take you to page 2 of that? Highlighted on that page, KPMG personnel on Lend-Lease audit team retained and utilised access to audit tender pictures in Lend-Lease board papers to inform their tender for Westpac's audit. Lend-Lease described these actions as not acceptable. Do you agree with that, Mr Longo?
I'm still reading
I'm
this.
so sorry, Senator. I'm just trying to... I don't know that we have a highlighted bit on our...
Oh, okay.
I'm sorry.
Second last paragraph.
Oh, I see. Sorry, Senator.
So if we just take point 5, I think that gives it the context, right? So since your statement in the Senate on the 24th of March 2026, and I do have copies of that if you need that to refer to. Do you need copies?
Have your statement.
We have yours.
Yeah,
yes.
KPMG has contacted Lend-Lease, and through further conversations, Lend-Lease has been advised of new information not previously disclosed to Lend-Lease, and the person that they're talking to is KPMG. The key points of those conversations can be summarised as following. Point A, KPMG has advised that KPMG's audit partner accessed via a folder in Diligent 2 documents from the Lend-Lease board papers. KPMG advised that these documents were put on a screen in the presence of the KPMG audit team, then tendering for the Westpac audit. B, in face-to-face meeting on the 31st of March 2026, KPMG showed one of these documents to Lend-Lease and advised the nature of the second document. Point C, KPMG acknowledged that the audit partner should have advised Lend-Lease that it had access to the audit tender folder in Diligent and should not have viewed any of the documents in that folder. And D, KPMG deemed the documents to be of low sensitivity and gave KPMG zero competitive advantage. And the statement that I want you to reflect on, if I can, Mr Longo, Lend-Lease has advised KPMG that the actions of its employees are not acceptable, and KPMG then go on to say they are in discussions with KPMG as to the action to be taken. So I seek your perspective on that, Mr Longo. And
Well, clearly, it's entirely understandable.
Just before the Commissioner responds, can I just advise the committee that 10 minutes ago KPMG Australia boss Andrew Yates quit?
we might get a copy of the news about that.
The article cites that it's due to the whistleblower allegations.
Thank you very much, Mr Buchholz. For your response, Mr Longo.
Well, I'll give you some observations. I think in the circumstances set out in the letter, it's entirely understandable from Lend-Lease's perspective that what happened was, to use Lend-Lease's word, unacceptable. There's clearly a breach of what would normally occur between an auditor and its client here. And as the letter itself points out, this is something that Lend-Lease and KPMG are going to have to sort out between themselves. But the circumstances that are set out in the letter are clearly unacceptable, and no doubt there'll be some further action that Lend-Lease will expect KPMG to take to ensure this doesn't happen again.
So I do know that there's a commercial relationship between Lend-Lease and KPMG. KPMG, I'm sure, has many, many clients who today would be going, including the federal government, who would be going, if they can do this to Lend-Lease, what the hell could they be doing to little old me? Somewhere further down the food chain in terms of strength, power and continuity of business status and capacity. So apart from that action of the commercial nature between the two who have engaged in a contract, Mr Longo, what actions is or can ASIC take to investigate and sanction KPMG on this matter?
Well, it's something that we've discussed, and I'll ask Commissioner O'Rourke to answer that particular question.
Thank you, Chair Longo and Senator. So I can confirm that ASIC has commenced investigations, a preliminary investigation into the allegations about the conduct of a number of the registered company auditors at the firm KPMG. So just to be clear, it's in relation to the registered company auditors. rather than the firm itself. But we commenced these inquiries after a meeting with KPMG on the 14th of April, and then after receiving further anonymised, in that case, information in writing from KPMG on the 29th of April 2026. So, as I think the committee's aware, KPMG has been conducting their own investigations and sanctions there, but we've identified that 3 of the 4 people involved are registered company auditors, and so the earlier comments therefore come under ASIC's regulatory oversight.
Okay, so 3 of the 4 people.
3
Can
of the 4 people.
identify who they are?
Thank you. Let me see if I can do so.
In front of us, Senator.
Sorry, Ms. Cole?
Sorry, Senator. We don't have that information in front of us as to who the individuals are, but we can take that on notice and find out
if you could,
if we're able to provide it.
Provide it in a timely way. I think it would assist the clarity of our communications today. I'm advised that the KPMG's head of audit is also stepping down from leadership and will then resign from the firm. Is that your urging, Mr. Longo?
I'm not aware that ASIC has asked for that to happen. So my understanding is this is a matter entirely between Mr. Yates. I understand the firm's head of audit also, Mr. McPherson, is stepping down. This is a very large firm with its own governance arrangements and structures. These decisions were made, as far as I know, independently of ASIC.
Just on that, Chair, has ASIC received any communication from KPMG in a letter or anything in relation to this matter?
Did they advise you that they were undertaking this action?
Oh, sorry, I referred earlier to, sorry, in relation to the, so I referred earlier to meetings and information provided in April. Is that your question, Senator Scarr?
Well, either that or a letter from KPMG in relation to Mr. Yates.
Senator, I might take that question. We received a letter this morning advising us of what's appearing now in the media.
So this is the point I'm trying to flesh out. That they did give you notice today before the story broke in the media.
I believe so. I've not had time to engage with the detail of the letter, but it came in just before the hearing started.
I'm a little surprised that you didn't advise us of that at the commencement.
Well, it might have happened contemporaneously.
As I said, Chair, I've just not had the chance to read the detail of the letter, but we were advised.
Can I ask you, through you, Chair,
yes.
so that perhaps you can have a look at the letter and then potentially I'd formally seek a tabling of the letter.
Absolutely.
For the benefit of the committee, please.
Thank you. Is there anything else in the letter that you think we should know about at this point of time? So we know Mr. Yates is gone, the firm's head of audit. Who's that person?
Chair, I'll need a few moments if we could come back to this.
McPherson, according to the press report.
Mr. McPherson and Mr. Yates, are there any other imminent resignations or changes to the leadership of KPMG that you're aware of?
I think, Senator, as Mr. Savundra said, this is sort of happening in real time, so we have a letter. We need some time to look at the letter and very pleased to table the letter. So if we can just do that in the morning break and come back to you, we're really sort of trying to digest it as we're speaking to you.
It wouldn't be a difficult question to answer. Are there any other names that we should expect to appear in the media of people departing?
Senator, if you can give me just a couple of minutes,
Yeah, come back with that and then we can go in more detail once we get a copy of the letter. Thanks.
Chair, could I just note...
Mr. Longo.
It's not unusual for me or a commissioner to be given a heads up about a particular appointment or on this occasion a particular resignation of a major entity. It is not ASIC's practice, there never has been, for us to be announcing to the media what the relevant resignation or appointment is. So it was certainly through no disrespect to this committee that we didn't mention the existence of the letter. It's just, we were given a heads up. It's a matter for KPMG to then make their announcement. It's not something we would normally do. So with no disrespect intended to you or the committee.
And I note that, Mr. Longo, and I'm sure that that's sincere. I just think it's very interesting that unless the Secretariat advises me we didn't receive such a copy of a letter. We'll go hunting just in case.
KPMG didn't give us a heads up.
I don't think so. And I think that probably the public record reveals that.
Absolutely.
I think they know where we all are today, but...
Yeah, they might do. Clearly, the issue of trust is critical in audit. With regard to the board papers and the specific matter of Lend-Lease, what elements of the trust equation, which is part of what you would oversee with those registered company auditors, has been breached in that particular instance?
Thank you. As I mentioned earlier, Senator, we have commenced an investigation in relation to some preliminary investigations into the allegations of the conduct, with the focus being on the duties under the Corporations Act that a registered company auditor must comply with. At this point, our work in relation to that...
Sorry.
No, that's okay. At this point, our work in relation to that is too early to conclude. I think your question is what has been breached. I think we're too early in our investigations to make any conclusive statements to that end. But we are looking at each of the specific duties that do apply to a registered company auditor, including with respect to independence. As you know, the area of conflict management and independence is an area of extensive focus for ASIC over the last couple of years, and those general independence requirements and specific ones, which prescriptive ones, which have a more limited scope, areas that we'll be carefully considering. You'll know as well that the auditor registration process has a number of different aspects of it, including capability, skills, but also fit and proper provisions, and so that will be another area for our inquiries.
Okay, so just before I move off this fit and proper, I think there's a common understanding of that. In your parlance, Ms O'Rourke, what constitutes a fit and proper person to undertake audit and to lead an audit company?
Yeah, thank you. I think it's something that's a very, very important part of the requirement that we assess as people become auditors. As I said, that capability, skills, qualification and experience is very important, but to be fit and proper, the conduct of the person in taking on such an important role in verification and assurance of financial statements is significant. So we do have regulatory guidance in our RG 180 that sets out the different elements that in a practical sense we have a look at to assess fit and proper, but I think you can set beyond those, or the policy basis or the policy goal that they're leading to is about the kind of ethical standards that we talked about earlier in APES that might not be technically what's applied, but I think your question is, if you step back from the specifics, what sort of conduct, ethical conduct are we expecting of our auditors? And I think we do expect a high level of ethical conduct.
And in your view, is the behaviours that are documented in the letter from Mr Lombardo, do they meet the fit and proper test?
I think the answer is in the fact that ASIC has got an active investigation to explore that, because we have concerns that they may not be so.
Thank you very much. One of the critical tools of management of ethical behaviour in these large companies, it's been put to us on many occasions, is the concept of ethical walls. How are ethical walls in a partnership meant to operate, Ms O'Rourke?
I haven't heard that phrase, ethical walls. Certainly independent, like information barriers.
I think we used to use a much more jaundiced term,
yes, which we don't need
people understood, but we don't use that anymore.
No,
but
that's
that's the concept to which I'm referring.
Yeah, information barriers,
yes.
I think. And I think that idea of while one firm may be working for and engaged by multiple clients, to the extent that they are required to be kept entirely separate, I understand, and we have a managing confidential information guidance as well, because this applies to lots of different firms, about the very practical and extensive steps that are expected if one firm is acting for more than one obviously they act for more than one client, but more than one client, where it's essential that they're kept the information and the contact between the people, as well as the IT or the document management systems, being completely separate.
Thanks, Ms O'Rourke. And thanks for your indulgence, colleagues. I've got one more question and then I'll come to Senator Scarr and then I'll return to this a little later. But Mr Longo, are you aware of the whistleblower allegations in toto that I raised in the Senate in March of this year?
I'm generally aware that whistleblower allegations have been made, but I'm very reticent about being able to talk about the content of those allegations, and I think I'll again defer to Commissioner O'Rourke, who's done a lot of work on this topic.
So I think at this point of time, if I can summarise, you are aware of them, ASIC is aware of them, even if you're not intimately involved with it, Mr Longo?
And you're referring to the whistleblower allegations that were shared with the...
Correct,
yes,
that I put into the Senate.
Yes, thank you. We have that transcript.
Okay.
Thank you.
And can I assume, given your answers already, that you have some interest in those allegations?
Yes.
And it has triggered some action from ASIC?
Yes.
Including the commencement of an investigation?
Thank you. Yes, I refer... Oh, sorry.
I was just going to say, just noting the committee's interest, Senator, just to put a bit more on the record and to be as forthcoming as we can. So as Commissioner O'Rourke said, we've commenced a preliminary investigation into allegations about the conduct of a number of registered company auditors at KPMG. Ms O'Rourke gave evidence a moment ago. 3 of those are registered company auditors. We started those inquiries in April. We've had further anonymised information, as Commissioner O'Rourke said, late in April. We have issued a number of notices to KPMG for production of information. We've been informed by KPMG that they intend to claim legal professional privilege over much of their investigation material, and I know we have had lengthy discussions at this committee on prior occasions in relation to the impact of legal professional privilege claims on ASIC investigations. So while that's not uncommon, that is something we'll have to navigate as we work our way through the investigation. So
if I can just interrupt to say, for the record, Ms Court, that we have considered legal professional privilege abuse and the overreach of legal professional abuse and its impediments, the impediments that it places on ASIC doing their job in the public good. That we have had that discussion many, many times. And I just think I've put on the public record that with regard to KPMG, if we have reached a point where there is sufficient interest in these breaches and sufficient acceptance that there's a failing to lose the CEO and the head of audit, it would be incumbent then upon those remaining at KPMG to cooperate fully with ASIC and not seek to abuse legal professional privilege in the way we have seen as a technique in the past. I just want to put that on the record immediately.
Thank you.
I'll come back to you for your final words.
Just in response to that, I obviously KPMG and everyone else, all other entities that are subject to ASIC notices have a legal right to exercise a claim for legal professional privilege, and we respect that, but we do expect the basis of any claims to be properly articulated. We may challenge claims if we consider them not to be properly made, and we have invited KPMG to provide the information to us under a voluntary disclosure agreement, which would be an efficient way from our perspective for KPMG to assist us with our preliminary investigation. But I can assure the committee that we are onto this, we are exercising our statutory powers, and we will be investigating in relation to those individuals that come under the ASIC jurisdiction.
There is a legal requirement that you've outlined, but there is also a moral requirement, and that moral requirement is a critical part that allows social licence for all of the good work that happens in our economy to be undertaken. So I would again put on the record my urging of KPMG to act with moral integrity and efficiency in its interactions with the ASIC inquiry into this matter and the other matters raised by the whistleblower. I can advise that the committee did receive correspondence this morning from KPMG at 9:51. That document is coming to us and we will also review in the break Mr Savundra, did you want to add anything at this point of time?
Only to respond to your question that the two individuals that have been named in the press are the only individuals that are contained within the letter.
Thank you very much. And I'll go now to you, Senator Scarr, and I expect other questions as well.
Well, thank you, Chair. And in terms of introductory comments, if I can just thank the whistleblower who brought this matter to the attention of this committee. And I think, Chair, it's fair to say that certainly, I'll speak for myself, we're impressed with the quality of the disclosure, and it immediately raised considerable red flags in our minds, given the detailed nature of the disclosure and the way in which it was presented. And now we're seeing repercussions flowing from that, which would not have flown but for the actions of the whistleblower, which underlines the importance of whistleblowers and the great good they perform for our community. And just in that regard, and I'm going to go into another whistleblower matter in the audit area, and this one relates to PwC and corporate travel management, and I'll just flag that with you, so to give you a heads up. But before I go there, I just want to delve into what recognition is given to whistleblowers under the Corporations Act who are actually employees of an audit firm as opposed to employees of a company. And I've had a look at the provisions, and it seems to me, and I'll happily be corrected, that the provisions in the Corporations Act are more directed to wrongdoing within a company as opposed to wrongdoing with an audit firm that is providing assurance services with respect to a company, which is incredibly important in terms of our financial system. So, and the concern that raises in my mind is whether or not there's a regulatory gap in terms of the protection of whistleblowers who are providing incredibly important information with respect to the audit of companies which are governed by the Corporations Act. So, interested in your views in that regard.
Yeah, thank you. I think this question of the protection of whistleblowers as it applies to organisations that aren't companies was canvassed in the PJC report. The inquiry into ethics and professional accountability, structural challenges in the audit, assurance and consultancy industry that you guys prepared, which was delivered on the 7th of November. So I do think that issue has been identified as a question mark, whether the Corporations Act whistleblower protections should be extended, and it turns on that definition of regulated entities as being application.
So yes, we've certainly raised the issue, but what's ASIC's view with respect to that? So when a whistleblower who's from within an audit organisation, a partnership, or it's worked for a partnership, reaches out to ASIC, how does ASIC apply the Corporations Act provisions?
Senator, thank you. So it's not ASIC's role to, unfortunately, advise individuals. I think, to go back to your original question, there is an issue or a gap there, clearly. In terms of the protection, we're not in a position to advise people whether they're protected or not, and that's a complex question which will need to be looked at through the individual circumstances of each employee, their employment arrangements. Some of these partnerships do have corporate entities associated with them, so they could be a contractor or employee of that corporate arrangement. So it's difficult for us to provide definitive advice. But what we can say is that we will treat someone that comes to ASIC and believes they are a whistleblower or on a lay, non-legal basis appears to be a whistleblower, we will treat them as if they're a whistleblower, meaning we will anonymise their information in terms of how it's recorded.
Yeah.
It's recorded securely. But what we can't give any assurance on is their protections under the law, which is difficult. So that's the approach that we take. But I think it's fair to say there is an issue there about employees or others within the context of a partnership not being protected by those whistleblower protections, which are to apply in a corporate context.
So, and that includes employees of audit firms that are partnerships, which are providing essential audit services to corporations which are heavily governed by the Corporations Act. Is that correct?
That's right.
So the whistleblower is in a position, not just in this case, but generally, where there isn't really any government, at least any government organisation that can provide them with advice with respect to their rights, with respect to their protections, with respect to how to navigate these extraordinarily difficult provisions, which even I, as a lawyer, 30 years standing or whatever it is now, have trouble navigating through. There's no one to act as their guide, their navigator, assisting them to deal with this complicated regime. Is that correct?
That's right. In terms of government support, we encourage people to seek legal advice to assist them with that process.
Which again, and I note your encouragement, but again, you're seeking a whistleblower who's trying to do the right thing.
Understand.
And the onus is on them to seek legal advice, which would be extremely expensive, time-consuming in a situation where no doubt they've been subjected to, in many cases, very onerous human resources responses within their own organisation. Their career may be under threat, their livelihood may be under threat, and they potentially don't have the financial capacity to get that detailed advice. That would be a fair assessment, wouldn't it?
Yes, Senator.
And if a whistleblower in that situation determines that they simply don't have the capacity to get that advice, then it could well be that we are deprived of the information, the very important information which they could bring to the public attention. Is that a fair comment?
It is, Senator, and obviously what's occurred here is protections that come through parliamentary privilege.
And you're also, and I note that you carefully watch the activities of this committee and consider its recommendations, and Chair Longo has referred to the many inquiries we've undertaken over the last few years, and you're aware of the report which Commissioner O'Rourke referred to also recommended the establishment of a whistleblower protection authority to provide a means by which whistleblowers could obtain that advice with respect to these very complicated matters, get that support, get that protection, have someone standing in their corner as they take actions in the public good. You're aware of that recommendation from this committee?
I am, Senator.
Thank you. I want to move to the matter of corporate travel management. And before I go into this matter, I'll simply ask firstly, because I don't want to take you into areas you can't go. I'm alive to that. But does ASIC have any investigations currently underway in relation to corporate travel management, noting that it's been in suspension, suspended from trading on the ASX since August 2025. We're now sitting here in late May 2026. The last financial accounts I could find lodged on the ASX announcement platform relate to the half year ending 31 December 2024, and I'll make some comments with respect to some statements I found in that half year report shortly. CTM made a announcement to the market on 22 April 2026, which I'm going to seek to table, Chair, and provide copies to the commissioners and my fellow members. Does ASIC have any inquiry in relation, ongoing investigation into corporate travel management?
Yes, we do, Senator, and there's a range of different limbs of the issues that we are thinking about, Senator. So perhaps I'll put those on the record at a high level and then answer any questions that you have,
if you could,
in relation to them. So in relation to CTM itself, just turning to one of the issues you've already raised, the issue of the lodgement of financial reports and delays in providing up-to-date financial reports. You may be aware that CTM are late in filing more recent financial year records. They have requested extensions from ASIC for the filing of those reports on a number of occasions, and ASIC has refused now any further extensions. So from our perspective, the financial year records and financial reports are well overdue, and so we are considering action we might take in relation to that. Separately to that, we have a stream of work. As you say, there were a number of announcements made to the market. CTM ceased trading in August 2025. There were announcements to the markets made in November 2025, and you've referred to April 2026. We're aware of those announcements. We have an open investigation looking at continuous disclosure issues and directors' duties as well, Senator. And then the third limb of issues that we are considering is, and it's relevant, I think, to the issues we've been discussing this morning, are looking at the work that PwC did in relation to the audits of CTM over many years. So we have an active investigation underway in relation to that. There are some registered company auditors that were involved, so that's our jurisdictional hook, if you like. So we have been looking at those issues since late last year.
And just in relation to PwC's role, is it true to say, Deputy Chair, that this was a situation where PwC had been a long-standing auditor of CTM? There was a change in auditor and rotation of audit firms is an issue which has been subject to great discussion over many years. Deloitte became the new auditors and identified irregularities with respect to, in particular, contractual payments paid by the government of the United Kingdom with respect to services provided in the United Kingdom. Is that correct?
Perhaps if I can just step through my understanding,
yes,
Senator,
please.
Which is largely in accord with that which you've just outlined. So PwC was appointed as auditor of CTM commencing in 2010 and continued to be the auditor through until September 2024, so a very lengthy period, some 14 years. And it was that at that stage...
Sorry to interrupt you, but I think CTM might have been listed about the time when PwC commenced. I might be wrong in that regard. But
I'm sure of it. Somebody will let me know
anyway,
the date of listing, Senator. As you say, Deloitte took over the auditor appointment, and then through sort of from September 2025 through to April 2026, following Deloitte taking over, there's been the various disclosures to the market that following a forensic accounting review, the company is expecting to reverse up to £118 million, so about $220 million Australian in revenue that have been recognised in financial year 25 and prior financial years dating back to financial years 19, so over an extended period.
So that's nearly. So I just want to get this for the record to. From my perspective, to underline the importance of this. This is nearly $250 million Australian dollars of reversals in revenue that CTM had recognised in its previous financial accounts which it's now looking to reverse. Is that correct?
That's my broad understanding, Senator. Now, whether that figure has been confirmed, and I think work is continuing, I think the true state of affairs of the accounts, as I understand it, is continuing to be determined, no doubt, by Deloitte and CTM, but what we've seen is really a number of announcements over some months further making corrections, Senator.
Okay. So on 19 February 2025, Deputy Chair, I had a look at their last financial report that was lodged, and it was for the half year ending 31 December 2024. In relation to the European market, including the United Kingdom, the report said, and I quote, "With record new corporate client wins and a strategic balance between government and corporate..." not sure what I can't read my handwriting there. "The region is positioned to further strengthen its profitability over the long term." So in that the last accounts they lodged in relation to the European market, the UK market in particular, where it looks that they may have to make a reversal of over 200 million Australian dollars, they were spruiking the actual achievements they'd made in that market. Are you aware of that statement which they made to the market in February 2025?
I'm not personally sitting here aware of it, but I'm sure our teams are, and I'm sure it's one of the announcements or statements to the market that we are considering, Senator, as we continue an investigation.
And then I'm looking at the announcement which has been released on 22 April 2026. Do you have a copy of that, Deputy Chair?
I do now, Senator.
Okay, and it refers to, on page 3, the forensic review by KPMG UK of CTM UK, concluded customer contracts in the UK. It says KPMG UK's forensic review identified erroneous billing activity occurred given the challenges, they qualify it, given the challenges, the rapid and large-scale nature of the engagement posed for CTM UK's process and controls environment. Paragraph 3, following the detection of what they refer to as the differences amount, the exercise undertaken by CTM in 2023 was compromised because of A, omissions and misunderstandings regarding the facts and contract terms in place with the customer, and B, conduct by the former UK CEO. This led to misrepresentation by the former UK CEO to the customer regarding the differences amount and the refund of part of it. So the difference between what was billed and what should have been billed. 4, further, there was no independent corroboration, I emphasise that phrase, independent corroboration by CTM that the letter agreements with the customer were in fact signed by the customer. Now that's Audit 101, checking that letter agreements and other contracts which are being relied upon for financial reporting purposes have actually been signed and in effect. And I continue, and the customer has subsequently informed CTM that it has no record of the letter agreements, end quote. Now, would you agree, Deputy Chair, that actually checking that letter agreements and contracts have actually been entered into and are in effect with respect to material financial matters is part of the bread and butter of an audit function?
Yes, I would.
And then it has come to light through... are you aware of the reports this week in relation to allegations made by a PwC whistleblower with respect to the concerns raised by that whistleblower that the relevant members of the PwC audit team were not acting appropriately with respect to red flags that whistleblower had identified in the course of participating in the audits?
Yeah, as you know, Senator, there are some restrictions in relation to what we can talk about openly in relation to whistleblowers, but can I certainly say that at a high level we're aware of the issues that have been raised in relation to the PwC audits, and as I mentioned before, we have an active investigation underway in relation to those issues.
And I note, and the Chair might give a wry smile with this, that she anticipates what's coming, that PwC has appointed an independent law firm to engage in an investigation with respect to these matters.
I think you might have a very different view about what independent means from some of these companies that use this as a cover, it would seem.
But it does raise the question, obviously in our minds, as to whether or not ASIC, and just whatever you can tell us,
yes,
Deputy Chair, is going to independently look into these matters, including what information has been provided by this PwC whistleblower.
Again, Senator, I'll just talk at a high level to say we're aware of the issues in relation to PwC. We've got the names of the lead auditors that were on the CTM audits for the last several years. They were registered company auditors. We've got an active investigation underway, and I can't help myself but wryly observe that having independent law firms appointed to do these reviews will inevitably mean that we will be facing the same issues as we're facing with KPMG, and that privilege will be claimed over the contents of that report, or it's certainly a potential, and I think I'm right. Mr Savandra will...
Surely not. It is impossible for PwC and KPMG to continue to run ASIC round and round the table, costing the taxpayers huge amounts of money to battle them while they hide the documents that whistleblowers are having to come to the Senate to reveal. That is just an outrageous proposition that they should continue with such egregious behaviour. We've watched it, we've noted it, we've put it on the public record. I don't think I can make it any clearer than today. Stop abusing legal professional privilege. Begin to act in the Australian public interest.
And Senator, so I'm speculating on what we might encounter, but Mr Savandra will correct me if I'm wrong, but I recall that we've previously done battle with PwC in relation to a claim for legal professional privilege, and we were ultimately successful, I think, in that matter. But Senator, you're quite right. The amount of resources and effort that is required of ASIC to challenge these claims, and of course everybody has a right, and I don't want to, or we don't want to detract from the very important right that legal professional privilege is, so I don't want to detract from that, but I can say that we and many other regulators spend a lot of very limited resources, both internal staff resources and external expenditure on expensive law firms and counsel to make these arguments about legal professional privilege, and I do think matters could be resolved often much more efficiently were voluntary disclosure agreements with ASIC entered into to enable us to get to the bottom of what's really going on.
Thanks very much, Deputy Chair. And I should note also two other points just in relation to this block, Chair, before you perhaps rotate the call. The last full financial year report provided by CTM reported in relation to auditor remuneration, and PwC in Australia received $733,000 with respect to its audit. Its Australian firm received, but also $1.439 million was received by PwC network firms, which includes the UK. In relation to the audit of CTM, so materially over $2 million in audit fees was received for the last full year in which the financial statements have been provided. The second point I'd just like to tease out. We've got an Australian-UK cross-jurisdictional issue in relation to PwC again. Which raises
a moment on the horizon, I hope.
So not only do we have the legal professional privilege issue, we've also got the cross-jurisdictional issue in relation to what ability does ASIC, what ability does this committee have to obtain information and documentation that is within the province of the UK. So with respect to ASIC's position, are you in discussions with the UK regulators? So this is an issue of a listed public company on the ASX, which has substantial subsidiaries operating in offshore jurisdictions, in particular in the United Kingdom. The allegations in particular relate to audit matters, revenue recognition in the United Kingdom. To what extent and how do you liaise with the UK regulator with respect to those cross-jurisdictional issues?
Yeah, thank you, Senator. In relation to whether we've been liaising with the UK authorities on the CTM and PwC issues, I'd have to take that on notice, but I'm sure someone will let me know in the course of the morning whether or not that engagement has been had, unless Mr. Savandra is telling me yes, we have. Any other details, Mr. Savandra?
No other details other than to confirm we're engaging with the relevant regulator in the UK.
Okay, all right. Okay,
Senator, just whilst I've...
Before you jump off, can I just clarify that response is in particular with regard to CTM, or is it on other matters as well?
I believe it's CTM and PwC, but I'll if I could confirm it's both. But they're obviously connected.
Okay. And then if this line of communication is open, as you've indicated, Mr. Savandra, can I indicate the committee's previous forms, in its previous form, requested a copy of the Linklaters report, which was PwC's, and I'll put in inverted commas, independent review of the whole failure of PwC that's well documented in the public place to act ethically. That document has not been provided despite multiple requests by senators of this committee in the last parliament, and I put on the record again a request from this iteration of the committee for the Linklaters report, which is now trapped, as far as I can understand, by a clever structure in Britain. So it would be very good for us to actually see what happened there, and for PwC to take the moment, in, as I say, a redemptive way, to begin to rebuild trust, which is certainly in the language that they're using in the press releases they're putting out. So we need a bit of form to that verbal commitment.
And Chair, I just observe wryly that the latest reports suggest PwC in relation to this matter's going down the independent law firm route, which will probably be a law firm. I don't know where that law firm's located. It could well be located in the United Kingdom that's doing the investigation. It could well be we're left in the same position in terms of trying to access information which is ring-fenced in the United Kingdom, which would be extremely disappointing if that were the case. I'll just put that on the record before I hand the call back.
Thank you.
Senator, if I could just respond to your previous question about when CTM was listed on the ASX. I believe it's the 15th of December 2010. And just in relation to that international engagement...
So that means... So, sorry, Mr Savandra, that means PwC have been the auditors of CTM since it was first listed, and it does raise the question in my mind as to the accumulated amount of fees received by PricewaterhouseCoopers in relation to CTM, including in relation to the work provided in the lead up to listing, and how much revenue CTM and perhaps some of the partners had received in relation to CTM since it was first listed. But just for the record, so that means, I think, Deputy Chair, that PwC had been the auditors of CTM from when it was first listed up to 2024.
It appears that way.
Financial years 19 through to FY 19 through to FY 24 were the years that PwC was the auditor.
Oh, sorry. What about before then, between 2010 and 2019? I thought the Deputy Chair said they'd been the auditors from 2010.
Yes, I did say that. So we'll clarify that over a break,
Yeah,
Senator, but that's certainly the information I've got in front of me here.
And I think I'm talking about auditors being the individual rather than the firm.
Oh, okay.
Yeah,
I
so,
understand. Yeah, I understand
so let me
the distinction.
clarify that.
I understand the distinction. Yep.
I'll come back to you.
Yep.
And just in relation to that international engagement, it's in relation to CTM at this stage, but we anticipate that will extend in relation to PwC in due course.
I anticipate it will too, Mr Savundra. Thank you.
Just reflecting on that observation, and we've traversed this territory quite a little bit, the registered company auditors and the limitation in terms of holding the entity to account. Can I just indicate, though, that we do have the resignation of Mr Yates today, and the reality is that Mr Yates has left because of his leadership role, but alongside those registered company auditors is every other partner in the structure that operates here in Australia. So partners are, in my understanding, joint and severally liable for the actions taken. And I would observe that KPMG and the rest of the Big Four are hugely significant entities for the Australian economy. And if I can come back to my issue that I've been harping on about all the time, and the reason for my motivation in pursuing this is the superannuation of every Australian. You know, just pardon me for being a bit partisan here, but this is a proud Labor legacy that has been embraced by all governments following. And no one's going to stand up for superannuation more than me. I never heard the word until I was an adult. I've got no connection with it. I didn't even know what a public servant was when I was a kid growing up, because it wasn't in my world. And there are many Australians like me who put their trust in really brainy people who they believe are ethical to hold their superannuation in trust, and those trustees require accurate, authentic information about what's happening in all these companies of the kind that we're talking about this morning. So I want to put on the record that that is my motivation for continuing to do this, and I will not rest, because superannuation is vital to every Australian. And when we talk in quite esoteric terms about some of the requirements under corporations law and partnerships and structures, it all becomes a little inaccessible. But Australians understand that, you know, the facts about what's going on in companies actually matters. The facts matter when they're doing their finances. The facts matter when companies are doing their finances, and auditors are there to make sure there's truth-telling. I think we've seen a remarkable failure of that, and I cannot see how partners at KPMG, despite your lack of a regulatory hawk, can consider themselves absolved of what's happened. Right? They took the money from the profit that's been made by these behaviours. They can't run and hide now, despite a lack of a regulatory hook, which was a term I believe you used. So I just want to say that before I follow up on the point that you made about the continuity of having an auditor and what happens when there's a change. Obviously, Deloitte picked up the PwC issue.
Well, the continuity of an audit firm.
Correct.
To take the distinction which Mr Savundra underlined, you can have a rotation of the actual registered auditor, the person who's doing the audit, but in this case, the issue came to light after there was a change in the firm.
Correct.
To whom the registered auditor was a partner of.
And Senator, I can confirm PwC was the auditor from 2010 through to 2024.
Okay.
So from listing.
Yep.
Senator O'Neill, just with your leave, can I just correct something that I said earlier, just while it's fresh? We were talking about claims of legal professional privilege, and I think I suggested, if I didn't say it expressly, that we had a case where PwC had made a claim. I misspoke there, which is why I shouldn't speak from memory without the facts in front of me. What actually happened, it was in a separate case that ASIC was running where that firm made a claim for legal professional privilege over a PwC report. So it wasn't it was the PwC did the report, it wasn't a claim made by PwC. So I just want to correct the record there.
But having said that, Deputy Chair, in the context of legal tax work, which PwC had provided over many, many years, there were serious concerns around inappropriate claiming of legal professional privilege by PwC, wasn't there?
And in their actions with the Australian Taxation Office.
We recall it very well.
I'm sure you're better placed to comment on the tax issues than I am. But the point still, the point is the
point
same.
still stands.
Indeed. Thank you. Thanks for indulging me with the correction.
The proper use of LPP happens when people exercise ethical muscle rather than financial advantage at any price. I would put it that way. Can I just table a document that clearly indicates that a KPMG, the title KPMG remains on call as Lend-Lease's Audit Plan B. It's an article by Michael Bleeby, Nick Lenehan and Edmund Tadros from 2023. And I table it because it reveals, not surprisingly I'm afraid, that Lend-Lease has had KPMG as its auditor since 1958. So that's just for noting. We've got a 10 or 15 minute block before we break. I'm just going to go, if I can, to a table in ASIC report 817, and I've got multiple copies here for colleagues and for you if you wish a hard copy. So,
can you remind us which report that is, please?
Yeah, it's Building Trust. I better keep one for myself.
Oh yes, thank you.
There it is. Go to the front page. Building Trust. Auditors' compliance with independence and conflict of interest obligations. Published October 2025, ASIC report 817.
Yeah, thank you. I've got it here. Did you say which page you were at, Senator?
So, having tabled that, on top of page 9 of the document, if I could take you to that. If you could just read that first paragraph for me, Ms. O'Rourke.
No
Thanks.
problem. So the paragraph comes under a title about auditor independence. So this is a description from ASIC, a summary of ASIC's position with respect to this issue. So it reads, auditors are legally required to be independent from the entity they audit to enhance users' confidence and trust in an entity's financial report. The auditor independence requirements, discussed below, recognise that independence has two dimensions, independence of mind and independence in appearance. Independence of mind means that the auditor is able to form an objective and impartial opinion of financial statements, free from conflict of interest, bias or undue influence. Independence in appearance means that the auditor is seen to be independent by a reasonable person with full knowledge of all the relevant facts and circumstances. In other words, perception matters and not just the auditor's state of mind.
Okay, can you reflect on those quotes, and particularly as it relates to the matters we've been discussing this morning so far, and your knowledge of what's in the public with regard to the KPMG matters?
Yeah, as I said earlier, this question about conflicts and independence has been an area of concern for ASIC. We've looked at it through the lens of work that we've done over many years as we've looked at particular audit files. But a couple of years ago, we did make the decision to do a deep dive in relation to conflicts of interest and independence because of its significance. So this is something that ASIC has recognised as a particularly important component of our framework that applies to auditors. And I think the value of the summary there is that it focuses on the financial statements being reliable, as you said earlier, whether it be for superannuation firms that we've all got a connection to, but there's plenty of people who are retail investors who are making decisions themselves based on financial statements. And so that you've spoken to the significance of the outcome, the financial statements being reliable and consistent. And I think what this paragraph does is describe the important contribution to that outcome from an auditor's independence.
General independence requirements is something that you mention here to ensure activity does not continue in conflict of interest situations. Have you been following along with the declaration or the reveal of relationships within and outside KPMG? I'll just give you the opportunity to comment on what you've read in the papers with regard to conflict of interest situations that seem to be being aired in the public place around KPMG.
Yeah, thank you. I'm not sure if I can repeat them with precision, but I can say that we have seen that some of the questions around relationships and are ones that are similar to those that we examined under this work in relation to general requirements, such as professional or social close engagement there. So if I can take you to the part of the report that does speak to those general independence requirements.
Where I was just about to go.
Thank you.
Relationships with office holders who are ex-partners. I thought that was a pretty interesting
Yeah,
spot.
that's right. So I think that we, our findings in relation to this report recognise the importance of people taking not a narrow or box-ticking approach to assessing their compliance with their general independence report, but rather stepping back and seeing whether there's multiple touch points or if accumulating over time, the length of time that some of these questions or relationships have existed does ask them to think about whether they remain independent as they're required to be.
So you write in this report on page 24, we found that some auditors appeared to focus more on meeting prescriptive requirements of the Corporations Act, showed less consideration of whether they were meeting their general independence obligations. We didn't see sufficient evidence of how auditors considered actual or perceived threats to independence that could arise from professional ties to office holders that we identified more broadly. And this was gleaned by you in your oversight of how many entities?
Thank you. I think we describe in the appendix to the report, so if I take you to page 30, the methodology that we used here. So it was a little bit unusual. So we started as broadly as we could to combine internal and public data and to kind of bring those data sets together in relation to income of non-audit services, so we're not really particularly talking about that part at the moment, but length of audit review, so that's the prescriptive one, the auditor one. So the office holders, that office holder relationship, and some of those other ones. So we did some data cross-matching. From that wide piece, we identified 123 audit clients conducted by 109 auditors, and then from those we looked more closely at 48 auditors for a review. So it's not a very large sample size. It started wide, but we took indicia to have a deeper look at 48 auditors, and that was in respect to 53 clients. So they were ones we thought that there may be concerns based on that preliminary data matching. So it's not a random sample; it's a identified sample. So they were that's the basis or the size of the sample from which we drew conclusions, as you've seen in the report, both with respect to the prescribed independence requirements and then the general independence requirement.
For the committee's purposes, noting Appendix 2, you identify the audit firms that were involved in your review. Amongst them was Deloitte, Ernst & Young, KPMG and PricewaterhouseCoopers. So EY and PwC as they're more commonly known. Could I ask you to take on notice an indication of what I might call a heat map of where these particular independence behaviours were most noted?
Yeah, sure.
And provide that to the committee.
Can I, at a general level, I can say that our conclusions with respect to the prescriptive specific requirements not being observed were concentrated in small firms. It was in relation to the general independence requirement, so I think you were just drawing me to that we saw concerns across a range of firm sizes.
Okay.
But I hear your request is for even more specific heat map, so let us take that on notice.
You examined cases where an ex-partner or audit firm had gone on to become an office holder at the client, which is, a signature of some of the concerns that have been raised in the current KPMG matter, and doing so after sometimes having audited the client while at the audit firm. I think Australians understand, like when you're supposed to come in and be the, if I could put it in a common parlance, like the policeman, it's hard to police your best mate, especially if they did things like be your formal sponsor to partnership, have ad hoc catch-ups with you, professional interactions and social interactions that continue, attending alumni and other events, office holder held leadership positions while they're at the audit firm, a relatively short time. You identified all of the things that looked like the formula for failure of auditor independence in your report, and we see in the whistleblowers' evidence to us, to this committee, and the parts of it that are now released, all of these behaviours.
Yep, and that's why we are particularly concerned. This has been an area of focus for ASIC over the last couple of years. This report is very clear about us seeing these as threats to independence.
You note some auditors stated they did not consider that the relationship characteristics described above created a conflict of interest situation, and they did not appear to consider that such relationships could pose a threat to independence. That is like alarm bells absolutely ringing in my ears. To actually manage a conflict of interest, you've actually got to see it first. And that requires an ethical disposition that seems to be absent from sufficient people in the sector that you oversee, that they don't even consider relationships an issue. So, look, there's much more to traverse in the course of the day, and I want to share the call, but I think we might just leave it there for the moment and go to the morning tea break and return at 11:05. Thank you. Thank you. The committee will resume. Hope you all had a good morning tea break. It's thirsty work this morning. Over to you, Senator Scarr.
Chess.
Something I plan to return to.
Oh, do you? not in terms of settlement systems.
I've got all the chessboards at home. I look at them, they're all beautiful, but haven't been using them much. I assume that's what you want to talk about.
No, unfortunately not. Unfortunately not, though I suspect you would be a very accomplished player, Chair. But I'm actually talking about the ASX. And this is set out in the ASIC's helpful submission, the final report findings of the expert panel appointed by ASIC to look into the CHESS system ASX. And I was left to reflect on the final report findings. The key observations of the final report are consistent with the interim report and include that A, resilience of critical market infrastructure has been compromised to deliver high shareholder returns. B, governance arrangements failed to provide the necessary focus on critical market infrastructure. C, ASX lacks the aspiration. ASX even lacks the aspiration, let alone the capacity, but the aspiration to be a steward of critical market infrastructure. And D, capability and cultural barriers. So not just capability barriers, cultural barriers are hindering transformational change. And then in paragraph 116, in addition to the interim report, the panel observed that risk management compliance practices need to mature to become fit for purpose, and B, limited competitive pressure had contributed to suboptimal decision-making and risk management outcomes at ASX. In the panel's view, the emergence of greater competition is unlikely to occur in the foreseeable future. So that was the recommendations that and observations made, or the findings made in the final report. So, Chair Longo, you've been on this journey over, if I could call it a journey, over the course of your appointment. And I note that from my perspective, at the start of your appointment, you were very fair and reasonable in terms of your dealings with ASX. You took on board in good faith their representations, their plans. You always emphasised to us, quite rightly, that ASX was primarily responsible. They're the deliverer of the project, not ASIC. And yet, 5 years later, I'm left to reflect on these final report findings, which continue to refer to all of these material issues we'd spoken about and our concerns about the resilience of critical market infrastructure being compromised to deliver high shareholder returns, lack of aspiration, governance procedures and cultural barriers. So I'm very interested to obtain your reflections on this, where we're up, where the journey we've come on, yes, what we can learn from it, and how you see the path forward.
No, thanks for the opportunity to answer that question. I will offer some very high-level reflections, and I'm going to try and step back and be objective about it. I think it's fair to say, as an opening proposition, that between us and the Reserve Bank, regulating and supervising ASX has proven to be an extremely frustrating and challenging thing. And they really are a unique entity in the Australian economy. They're not a bank, they're not a superannuation fund, they're not an insurance company. They operate critical market infrastructure. They're listed on their own exchange. And if I may say so with great respect and without casting aspersions, they've been pretty lightly regulated over many years. And so when Sarah Court and I started back in June 21, it was my then belief that the supervision and regulation of ASX had to be intensified. And
And so just very quickly, this is very high-level chronology. Later that year, we imposed licence conditions that ASX accepted. There were then a series, as you know, CHESS replacement A was abandoned. They started again. In the meantime, we upped our supervision through calling for the first time under, I think it's 825B of the Corporations Act. We called for independent reports that had to be audited. 3 of those. I won't go into the detail of what each one was about. We then took the unprecedented step along the way of holding ASX accountable for statements they made in February 2022. Statements, I might add, that were unforced. So these were statements made to the market in February 2022 along the lines that CHESS replacement, this is paraphrasing, okay, because this is all subject to a hotly contested court case at the moment, was going well. I'll just...
On track.
But I want to stress we've pleaded the specific statements that we took issue with, but that's the gist of it, that things were okay with CHESS replacement.
And I think, Chair, I actually put some of those specific statements to you through the course of proceedings in this committee.
You'll appreciate that there's not a lot I can say about that matter now. That the trial in that matter starts in 2 weeks or so, middle of June. So we're now into the last 12 or 18 months, and it's clear that ASX is simply not making the progress that ASIC and the commissioners were expecting. Along the way, this committee made its own findings about what needed to change, including ASIC itself increasing its capability, which we took on board. I can talk about that in more detail if necessary. But by the middle of next year, we announced this inquiry, again unprecedented, because we were looking for a circuit breaker. We were looking for a way of what do we do with this entity? It's simply not making the progress that we wanted of it. And so in my remarks at the beginning of the day, it's sort of like an interesting case study. Well, what are we supposed to do? Sue them again? Investigate them again? That just simply wasn't going to work. And so the commissioners gave a lot of thought to this in the first half of last year and said what we need is a sort of a holistic inquiry, and we'll get it done independently by 3 individuals of high standing, and that's what happened. So from I think around the 1st of June last year, the inquiry started, and Senator, I won't repeat, you read out where they landed. And so I see the work of ASIC and this inquiry the last 12 months as really laying a roadmap to ASX and saying, look, you've really got to face up to this now. I used the word hubris at the very beginning when CHESS didn't work, and it's true, it was hubris. There was shareholder supremacy and priority. They did drop the ball on investing in technology. There were cultural issues. And so I think and just recently we know an announcement has been made about a new CEO. And this week, quite remarkably, a very significant drop in the ASX share price as it came. I won't try to summarise the financial details, but clearly the market now knows and understands what the cost will be to invest in what should have been happening a lot sooner. So I acknowledge the work ASX has done so far. They've made some progress with governance and culture, but I absolutely also believe that we're at the beginning of the beginning. To channel Churchill for a moment, for the first time we imposed a capital charge. Now there's the legal framework around that isn't as clear as we might like, but to ASX's credit, they agreed to the imposition of a capital charge. And we were looking for a way of concentrating the mind of the board on what needed to be done and the investment that was required. Consequently, in order to fund that capital charge, it had an effect on their dividend policy. And of course, that's the shareholders. So the shareholder primacy aspect of this is really quite fundamental. Companies change when shareholders, okay, it helps if the Parliament encourages them, and it helps them if the regulators encourage them, and it helps if the odd entity sues that company because they want change. But the real driver of change in any company is the shareholders. And a key part of the findings of this inquiry is that they put the shareholders first in circumstances where, and that distracted them from the investment required in technology. Now that's a potted history of the last 5 years. I think we finally have something now where there's a roadmap. There's some significant details we haven't mentioned yet. The Accelerate program, I've mentioned the capital charge. ASIC itself has upgraded and changed its capability and strategic approach. We're working even more closely with the Reserve Bank. But I don't think, least of all me, I don't underestimate the mountain they have to climb. And I suppose the other aspect of this, and I know Simone Constant will also have some views, the other part of it that I think is really important for us all to acknowledge, and again I sort of mentioned this in my opening remarks today, is the technological change, and the tokenisation of markets is a good example. There's just so much going on in that space globally. The ASX has to keep up with that. And so what's happening in our global markets it also implies, for me at least, some serious questioning by ASX of its technology strategy. So it's not just Australia we're talking about. You know, we're talking about an entity that's playing within a global market. So ASX's performance plays out, for example, in the question of the growth and robustness of our public markets and whether they're sufficiently open to IPOs and matters of that nature. So it's a really big subject. And so I might just pause there. But I do want to, it has been, I think, a frustrating journey for the regulator. But I think we have now reached a point where there is a roadmap. And if I could just repeat what you said, Senator Scarr, ASIC itself cannot reform ASX. ASX has to reform ASX. And we will do our best and continue to do our best to hold them accountable.
So I might just then ask Ms Constant if you could give us your reflections then in relation to the public market dimension of this, because it seems to me, given ASX's special position with the management of this critical financial infrastructure, that to the extent ASX doesn't keep up, Australia doesn't keep up, which is deeply concerning in terms of opportunities for all Australians in terms of the public market. So interested in your reflections, Commissioner, in relation to this issue around technology and what's happening in overseas markets and the absolute importance of Australia keeping up.
Thank you, Senator Scarr. So consistent with what this committee has said in your own findings and the encouragement you've had in the years I've now been at ASIC, actually inconsistent with the panel's own words, at ASIC we consider that the reform and change of ASX is fundamental for Australia keeping pace and having aspiration for our place in the world. So ASX, absolutely, we start from the premise it is critical national infrastructure. It's been part of your messaging, part of our messaging, but it's at the centrepiece of the panel's reports, both the interim and final findings. So in that regard, the change that's needed and that's called out, like this, it boils down to 4 root causes, but this really goes to technology, strategy, governance, capability, resilience and aspiration. And all of those things need to come together, all of them, including the aspiration for this to continue to be a world-class venue for traded markets, not just listed equities markets as well. We often look to them in terms of the health of the public markets, but of course the ASX plays such a critical part, for example, in clearing and settlement, Austraclear, other key functions that actually at a time of stress and resilience is when their functioning is most important. So We think that we have in the interim report and the final report, but also the package of commitments, that we have a plan that gets to the root cause, so as opposed to hundreds of findings, like root cause and some commitments that will respond to that. That includes responding to that need for aspiration. Indeed, it was the panel's words. It will be critical for there to be the right governance, the right capability, like capability for stability right now, and for things like you started with CHESS, implementing the roadmap as it sits, but also that capability and that strategic thinking for where markets go, because we are in the fastest point of change in financial markets, not just capital markets, markets generally, that I think anyone's seen, that aspiration that can build on the strategy, the governance, the risk management, and fundamentally the change in technology to support it. The package of commitments we have through the response to the interim report that was really substantiated in the final report, they go to those drivers that include a capital overlay, so the $150 million capital overlay that's being accrued, that relates to that shareholder pricing, shareholder primacy, and the need for understanding that there needs to be an overlay and a retention and reinvestment of capital to support not just the stabilisation, it's well known the history of outages and some of the need for stabilisation and resilience, but that capital investment to match that aspiration. We've seen the call out for and the addressing of refreshed leadership. Now that's for the board and the shareholders to deal with and choose who leaders are. It was very clear that it needs the right leadership to not just get things stable, but to look to the future and understand ASX's critical national infrastructure role, hence the announcement around the new CEO. And we've seen the commitments. We're working toward 30 June where we'll be working with ASX to sign off or not on the refreshed Accelerate plan, and I'll kind of sow to that Accelerate plan because that's the details of the tech strategy and the other elements of refreshed strategy that will underpin the stabilisation phase that they're in, and then that reinvestment, that capital reinvestment and reform and refresh of technology for today, but for that kind of 5, 10, 15, 20-year aspiration that critical markets infrastructure has to have.
Okay. Just two supplementary... Just two quick... I could sense you, Chair. Two quick supplementary questions in relation to the capability of ASIC. How's the capability of ASIC been enhanced at a high level in terms of practical changes to assist in the ability for ASIC to perform
one
its
area
important role?
that we've certainly enhanced is our technical capability. So
what does that mean in practice? People or systems?
Well, I think historically we didn't have, as we do now, the competence and capability around rolling out IT projects.
Right.
And that sounds like a pretty mundane and banal thing, but we have, I think, a highly accomplished markets team that's expert at a whole range of things, and I think what we've learnt the last 2 or 3 years, and I'd be very interested in Simone helping me supplement this, is that a lot of what was going wrong at ASX or not going well enough was all to do with technology and rolling out projects and so as the regulator, I think we needed to improve in that area, and we did. We hired some really good people to help us interrogate more effectively and intelligently what they were telling us about their progress with technology projects, and I think we might have been able to do in the past, in fairness to everyone. So I think that's one area. I think another area, and I think Simone's already touched on it, I think it is a broader perspective around market development and market infrastructure and technology that requires a specialised input as well. But I think the big one, for me at least, was the increasing the capability around how do you more effectively supervise an entity that has this huge technology debt. So remember, this markets team has done amazing work across market cleanliness, market manipulation, market infrastructure in general, development of markets. There's a whole range of activity that doesn't require that technology expertise, but I think that's, for me, that was a big change.
Simone, did you want to come in with that?
Yeah, that'd be a pleasure. Yeah. Just to expand on that, the way we've thought about ASIC and what ASIC does in its approach is start with the joint supervisory approach with RBA. So as the panel identified, we need to make sure that we've got as high-functioning a joint supervisory approach as possible, not just so that that's the way the ASX feels it, but so that we can focus on getting the most effective outcomes that we want, so bringing the best of both organisations to bear. So we start from there and understanding our roles and working together. So, for example, we've created actually a standing committee, so that chaired by my peer at the RBA, and I attend, and as do some of our team, to make sure we coordinate on the key priorities. What are we most worried about? And quite helpful at the moment having the root causes and the commitments, but not just that. What are we most worried about? What are we going to focus on independently? Where do we need to converge and come together? Second thing I'd say is we focused on people. So Chair Longo rightly called out people first, people last, always in organisational health. We have great people who've been working in this space for many years tirelessly. Then we needed to boost that. So we've brought, for example, a new senior executive leader from the private sector who has operational risk, system implementation, AI experience, risk management capability to understand, who really understands sort of system implementation and these risks, and what organisations go through. Also what supervision looks like, because in this space we are frontline supervision. So we have almost a prudential role, certainly frontline supervision. And that team is being invested in, including, importantly, with some of the people who supported the inquiry. So I'll get to the inquiry in a moment, but the inquiry was supported by what we think was a pretty crack team, drawn from our own resources, but also APRA and RBA, because there's a lot we can continue to learn from peer regulators on supervision and how the RBA thinks about system stability. So a number of those resources have stayed in place to see things through. The third limb is governance. Governance is important for us as well. The Commission has established a Commission Markets Committee, which meets fortnightly, which I chair, that actually gives us the space and time to really dedicate and focus on these issues that have always been well focused on through Commission proper, but it gives that focus and space. And finally, I would say that a different thinking and approach is part of the capability as well. It's the first time we've done something like call together that panel. Thank you for your positive remarks about the way we went about calling the panel. We went and got that capability and expertise and opened ourselves up to that. So we held ourselves over to say, we're not getting the results we want. This is so important. Tell us, including telling us, give us insights for our own capability and how we do things, and we've responded to that. Tell us, what do you think needs to change? And they did 140 interviews. They read 10,000 documents, and they're three of the most eminent directors in Australia. So we brought that weaponry to bear because we thought of that kind of size of the problem. So we now have that intellectual property that we're taking forward, and we continue. The final thing I'd say on that limb, it's not the first, but it won't be the last of our engagement with the external market. Soon I'll be chairing a roundtable where we'll be inviting a whole lot of leaders in financial markets, including the innovators and the stabilisers, to turn our mind to not just what's happening now in ASX, but where your question was going, what's happening next and what do we need to do? You can only focus on a few things and do them really well in this space, but what are the big few things we need to do as ASIC to ensure that we are promoting and not getting in the way of the innovation that comes next?
Okay, so look, I congratulate everyone who's been involved in relation to that inquiry, including all the members of the panel, for their public service. It really is public service for agreeing to participate in the panel, and I also recognise the work of the crack team you refer to. I wrote that phrase down, crack team, from ASIC, so thank you to all the members of the crack team. And I think it's been a very important piece of work, so I really do commend ASIC in relation to it. My last question, which I think you can take on
Senator
notice.
Scarr, thank you, because that's very meaningful for them, so thank you.
If I can, you can perhaps take this on notice, but as you know, Chair Longo, over the last 5 years, I hang off your every phrase and word. And you mentioned that in relation to the capital charge, that the legal framework was not as clear as perhaps it could be. If you could just take on notice and maybe just provide us some detailed commentary in relation to that, because obviously we're interested
in the capital charge. Unlike APRA, we have very clear powers in this area. We don't, and so we did a lot of work at the time to bring that result about. So we'll have a quick go at answering your question now.
Sure.
But if there's anything left over to say, we'll do a supplementary quant.
Yeah. Yeah, we'll come back with the detail, but we had advice and had information that suggests this was available to us. The reason that we did not, what Chair Longo was referring to, however, didn't need to go through that route, for example, of using licence conditions or exploring other routes, was when the panel put forth the interim report, which we supported, the ASX accepted that and made that commitment to address those root causes with that package of commitments. And it will include, and they've given detail and they're underway on actually putting that capital base away that needs to be there this time next year, so we can come back with some of the detail.
Okay, thank you. Thank you, Chair.
Thank you, Senator Scarr, and I give the call now to Senator Whittaker.
Thank you, Chair. I've got some questions about the Money Smart Gen Z Financial Behaviours report, which is a really interesting report. So thank you for your work on it. There are a couple of things that really stood out to me about this report, which talks about how Australians between the ages of 18 and 28 manage their finances and consume information. And really the key findings which you point out in the overview of your report is that this generation of young people are highly engaged with financial decisions but are increasingly exposed to riskier investments through unregulated digital channels. And so I want to explore some of those with you today. I guess perhaps to start at a high level, when you say that young people are increasingly exposed to riskier investments, how would you define riskier investments?
So I'm going to ask Commissioner Kirkland, who did most of the work on that subject and has carved a niche out for himself in the radio world explaining it. So I can't possibly compete with the way he explains things so well.
Excellent.
So
Thank you.
It's okay, Senator. I'm going to ask Commissioner Kirkland.
Yes.
Thanks, Senator. I mean, those observations, I guess, were founded in some of the research findings about the degree to which young people use social media for financial information and guidance, which is by no means surprising. But in that research, we did find that 63% of Gen Z said they use social media for financial information and guidance, 30% use YouTube, 80% use AI platforms. And in terms of riskier investments, it's a fairly broad term, but to give you some of the examples, there are, I guess, several categories to our work. We've done a lot of work in relation to investment scams, where we commonly see people that might be exposed to ads or posts on social media that are about investments that actually don't exist. In some cases, they'll be encouraged to join private chat groups or sort of closed communication channels, which means it's much harder for us to see what's going on, where they're then subject to a hard sell, to be honest. Often the sorts of investments that are spruiked rely on claims about technology. So they might claim that superior returns can be achieved as a result of bot-driven trading that can outperform the market. There might be claims about the role of AI in generating superior results. We also see characteristics of some of the influencers that they're often using images that promote a lavish life cycle, posts that at least make it look like they're in exotic locations overseas, driving luxury cars. But often they're pointing people to investments that either are complete scams or involve higher degrees of risk. And so, for example, in the category of those that might be actual investments but involve higher risk, cryptocurrency-related investments are a key category that we observe. So that term riskier investments is a broad category, but we see quite a lot of examples where if people are getting information that doesn't accurately reflect that risk, then that can involve risks to those individuals if they place their money there.
And do you have a sense of who is behind this push in the digital space to young people? Is it do you think it's people based here in Australia? Is it foreign actors? Do you have a sense of where this is being driven from?
I think it's fair to say it's a mix. So, and sometimes it's not possible for us to say with or establish with certainty where somebody is operating from. If we can identify people who are operating in Australia who, in our view, may be breaching Australian law, then we'll consider taking action. So, one area where we've done that is in relation to finfluencers. So we've done several waves of action over the last few years in coordination with regulators in other countries, really cracking down on people giving financial advice online without the appropriate licences. And so as a result of that, or as part of that work, we've written to and formally warned a number of finfluencers that we considered were operating in Australia without the appropriate licences or authorisations. A number of them have changed their practices. They've stopped doing that, or they have taken steps to obtain the appropriate licence or authorisation, or they've modified their behaviour so that it's potentially not providing financial advice. So some of that work has been effective, but we then have also identified some people involved in that activity who appear to be operating from other jurisdictions, and it's much harder for us to act in those situations.
I want to turn to AI platforms, which your report also talks to. So 64%, you found that 64% of Gen Z have moderately high trust in AI platforms for financial information and guidance. I'm interested in what capacity do you have, if any, to regulate? I mean, you regulate financial advice as it's given by, you know, rightly or wrongly by finfluencers, as you refer to them. But do you have any scope to regulate an AI platform providing financial advice to young people?
It's an excellent question, Senator, particularly in the context of that research. And I think the best answer, as is sometimes the answer in relation to these areas involving technology and evolving business models, is it depends. So it does depend on the very specific circumstances. In general terms, if a person or an entity is providing financial advice in Australia and they're carrying on a financial services business in Australia, that would require them to be licensed. And financial advice generally involves encouraging somebody to buy a potential financial product, or influencing a decision that somebody might make about buying a financial product. So it would depend on whether that's the nature of the information that somebody's getting when they engage with an AI platform. It would also depend on whether the entity that is behind that, I guess, AI advice is operating a financial services business in Australia. And there are probably a few other more technical tests under Australian law. But I would say it's an area of great interest for us. We are looking closely at it, where it features prominently in my discussions with people across the industry. So in our discussions, some of which I do jointly with Commissioner Constant, with superannuation funds, with financial advice licensees, and a number of the other major institutions, it's something they're interested in as well. And I have to say there are a lot of people across the industry that have been very helpful in providing examples to us to help us understand what's happening right now and start to think about what our role might be.
And I guess sort of related but slightly different is, do you have a sense of how financial advisors are using AI to inform their work?
We don't have a detailed understanding of that at this stage. It does feature in our conversations with financial advisors. And so we know that, of course, a number of financial advisors are using AI because AI technology is embedded in so many common business tools. So I think we can just take that as a given. I think to the extent that people are giving us insights into how they're using AI at the moment in financial advice, what we're hearing is it's more in back office functions than in ways that are heavily involved in the advice that's provided to consumers. But again, it's an area of interest to us, and I think we'll be doing more work in that area over the next few years to understand what the current practices are, what the patterns of use of AI are across the sector, any areas of concern to us, and indeed how that's evolving, because it is an area that's changing and will continue to change very fast.
Yeah, okay. Thank you. That's very useful. That's it from me on that topic.
I'll go to Ms Jarrett next.
Thank you. Before I go into my questions, I just want to build on Senator Whittaker's comments, because I just Googled, I'm 25 and I want to invest in Australia. What do you recommend I invest in? And I got a lovely list, just FYI.
What does it say? Tell us.
Well, first it says have an emergency fund and then diversified ETFs. It talks about superannuation and then lists a number of different groups. So there you go. So yes, it's a difficult area, but I think one we do have to get on top of. But now back to my questions. I actually wanted to talk about, and we did this last time, public versus the private market, and I know you've got a lot of work underway in that space, but I understand the public equity market in Australia is about 3 trillion, IPOs are low. The global private assets under management have tripled in the last decade, and I saw a figure recently, $14+ trillion. I saw another data point recently estimating the Australian private credit market has increased 500% in the last 10 years. So we have, as you rightly said earlier in your in earlier hearings, that we have a shift happening in our market. Can we focus first on the public, because you do have a lot of work underway in terms of trying to accelerate IPOs, etc. How's that going? Are we seeing any slowing of the decline or even a turnaround?
Well, in terms of new IPOs in Australia, I think we can all agree it's been a bit disappointing that we haven't seen a big uptick. I should hasten to add, though, we're not alone in that. No. So even in the US, as recently as 6 months ago, the SEC chair, Paul Atkins, was giving a speech on this very topic, and I think he called it making IPOs great again or something like that. So this question of tapping the public markets is actually an issue that a number of jurisdictions are facing. Now, it's equally fair to say, I think, that the US is pretty unique in and of itself, given what's going on there with SpaceX and a whole range of other entities. It's an extraordinary public market. But the first point I would make is the issue we're facing with public markets, we're not alone. No. Singapore has these issues, UK. Now, I think ASIC, and I'll get Simone to comment on this in more detail, I think we've done probably as much as we can within our regulatory framework, within our regulatory remit to, I'll use the word encourage or facilitate IPOs. There's a little bit more work we're doing, but this is something the ASX, I think, has to look at more closely. The other aspect of this is that there are structural considerations about why investors might support a public market and why they may want to be, just at a high level in the private market. And we've published some, I think, really good analysis led by Professor Carol Comerton-Ford, who we commissioned to do this work. So it's a nuanced picture. The overall, we continue to try to be agnostic between private and public markets, but I think even having said that, the overall sentiment is I think we all benefit from active, robust public markets. As things stand, about a third to a quarter of the ASX is owned by our superannuation funds. I think we like the price discovery, the transparency, the accountability. Not so easy to achieve that with private markets. Before I finish my sort of very high-level markets, private credit's definitely something we are continuously looking at. Now, the data on that isn't great. We published a report middle of last year, and Simone might be able to correct me. I think we estimated the size of the private credit market in Australia this time last year was around 205 billion, which is relatively tiny. In the US, it's huge, and it's across a whole range of sectors across the economy, while our private credit sector tends to be concentrated in property, very often higher risk property investments and construction. Again, I'll ask Simone to speak a bit more about that. And we don't have
as much data as we would like. It's a bit opaque, and so we publish reports about where we think there needs to be improvement. And we'd also like, around disclosure and managing conflicts and valuations. I think it's fair to say there has been some hand-wringing about what's happening in private credit markets. But as far as Australia is concerned, it's sort of a pretty small part of our economy. But private credit done well, I think, is not to be discouraged, but it has to be done well. I think I might just pause there and see whether can I just ask Simone to sort of supplement some of those observations.
Just briefly, I would say we're at a point where you've, and thank you for picking up on our work regarding IPOs. The focus first on IPOs in the health of the public market was about continuing to do our best to be part of ensuring opportunities are brought to the Australian market. So, and I have some information on most recent listings, and there's been a couple this year. There's only probably been 2 of note, and Chair Longo has identified this is not just a domestic phenomenon, but we've tried to look beyond what is domestic and what's our part in this, and what part can we play. We're now turning, when it comes to the health of the public markets, we're now turning to the next phase in this next part in the journey of a company, staying listed. So one thing we identified when we went out and did all the work over the past sort of 18 months and asked all sorts of stakeholders, got 100 submissions, engaged in so many forums, was sometimes it can be hard also to stay listed and grow in the Australian market. And it's that balance of effective disclosure, transparency, and also some of the rules around listing, etc., that, as Chair Longo referred to, are more within the ASX's gift. There are elements of reporting, for example, we've talked a bit about reporting and assurance today, that we're going to look to understand from but the principles of listed companies. Are there things that we ask for that don't add value, that make it harder for them to resist the temptation, for example, to look to be taken private? So it's because it's not just about getting companies on the boards, it's getting them to stay on the boards and see this as a good place for patient growth, so we get that growth in productivity. So that's, and indeed where we're kicking off that phase, I chair a markets panel, a great group of leaders from all different corners of Australian markets. In the next couple of weeks we'll be opening that question back up. Okay, so this is something we heard about, the staying listed. What do you think? Are there 1 or 2 things that are within our gift we should focus on? Yeah. Secondly, I'd say we have been doing our work with ASX. We've talked a lot today about ASX's critical infrastructure. They also, the final report, the difference between the interim report and the final report that we've talked about from the panel, one of the key findings was that the sort of compliance and listings and corporate governance function within the ASX as part of the whole of the ASX refresh, investment in and refresh there, that will be important to see that happen, because that gives them the bandwidth, and they've put energy and time into that at ASX, but that's important so that they can consider their part, what's within their gift, to ensure we have the appropriate settings for disclosure and protection of investors, particularly retail, but also so we're an attractive place for listing. Yeah. Chair Longo talked about the international dynamics. And then the final thing I'd say is, in terms of the public markets, because I think that was the first part of your question, you might want to come back to private credit. Yeah. Of course, the rails, the ASX, the listed market, functioning, being reliable, being resilient, being aspirational, that's one of the reasons we focus so much on the ASX, so that for now and for what it looks like in 5 years when we're truly going to be even more global, that it is aspirational.
Yeah. I do want to go back to the private market too, because, and this is to pick up on a point from you, Mr. Longo, that, you know, it's roughly $200 billion, I think you mentioned as a figure, but, you know, some of our largest super funds have got 20% invested in unlisted assets, and that to me creates, makes me a bit nervous if there are higher risks associated with the private market. And I know, like you talked about, there are risks there and the lack of opacity. Do you think you could just give a bit more colour to that? Yeah.
Just step back. The private markets is a broad church. There's a lot. No. So private credit is a subset.
Yeah.
In my word, of the private markets, and a relatively small one. Now, people worry about it because there's a lot of hand-wringing about whether it's like contagion risk. If things go wrong in that market, it's going to have a broader stability issues for the system. Let's put that to one side. You mentioned superannuation, and I think that really is a profound topic. So the way I understand that is that I've mentioned between a third and a quarter of the ASX is super, and our superannuation sector is, I think there's no other word for it, it's extraordinary. It's now hitting 4+ trillion, and they're running out of, my word, investable assets in Australia. And so they'll invest in the public markets, and they'll do what they can to invest in private markets, which includes private equity, alternative investments. There's a whole range of investable ventures, I'm just trying to keep it high level, that are available in Australia. But if you've got 4+ trillion to invest, you're going to go offshore. And that's what our superannuation funds have done. And so they have a presence in the US and Europe, and they've been investing offshore for some time. And I think you're right about the statistic, though. I think it's quite interesting. Certainly for the bigger funds, the private market asset seems to be climbing 20% plus. And I'll ask Simone to comment a bit more on that. She's closer to some of those dynamics. But I think that at the heart of it is the approach of the super funds is global, and we can't expect them, in the interests of all Australians, to invest all that money just in Australia. This is not going to work. The way capital flows work now,
I get
they're sort of missing those opportunities. But if it's okay, I might ask Simone to comment a bit in more detail.
Give you just for some depth on some further depth on what Chair Longo has said. So I might start with the superannuation investments into direct investments or unlisted investments. As one of your colleagues on the committee knows as well as me, APRA definitely takes the lead when it comes to valuations and asset allocation around the attribution of the portfolio of APRA-regulated super funds, and a large proportion of the 4 trillion mentioned are APRA-regulated superannuation funds. When we did our work that we released at the end of last year on changing dynamics in public and private markets, we did go on record in saying that with the regulatory architecture we've got and the strength of APRA supervision, plus the strength that ASIC has in key instruments such as our reg guides around fees and disclosure that work with things like the performance test, that in the main, superannuation through APRA-regulated superannuation is in the main a good place to get exposure to private markets investments. And I'll let APRA speak for themselves around 20% versus 30% and how that works with things like liquidity. So in the main, it does require all of us to be regulating within our remit and paying attention. It does, though, mean that for every Australian, and the chair of the committee opened today with some remarks about every Australian has superannuation increasingly, that private markets are relevant for every Australian. So it's one of the reasons we focus so much on this. And you're absolutely right that when we think about global reasons for the changing dynamics here versus domestic reasons, superannuation is the leading idiosyncratic factor in shaping the dynamics of Australian markets because of its size. And so done well, that's a really good thing. Stepping back up then to just private markets generally, your questions on private credit, it's pleasing that you've picked up on our messaging that within private markets, private credit is one particular area of private markets that we really have focused on. A couple of reasons we've focused on it. One is that growth rate. So that is a global growth rate, but we are absolutely seeing the same domestic growth rate. In fact, it's probably disproportionate growth versus private equity, the other type of private investment. Doesn't mean it's bad. We always say private credit done well is good for investors, good for the flow of credit, good for the economy, and indeed it's a necessary correlation to some degree of the way banks are required to price certain risk. That said, there are some Australian factors and some global factors that have our attention. And just to quote, some of the global voices, it's a good statement. Private credit is facing what many are describing as its first real test at scale. That's both global, but it is also domestic. And so paying attention to what's happening globally, and the global private credit is somewhat different to Australian in its complexion. Australian private credit tends to cluster more, for example, in property and construction and development, which can be a good or bad thing. So that concentration can be good or bad. Some of the challenges globally have been in, for example, software. So as software is devalued with the rise of AI, there's been a lot of private credit caught up in that. So there's some differences there. Not to say that Australian institutions are immune from that. There are certainly some institutions participating in that, but there are differences. But paying attention to that and our findings last year, and I would just again recommend Report 820. our private credit surveillance report, where we identified some very poor and concerning practices in domestic private credit by looking across 28 funds. There's 3 or 4 actions I'll outline we have underway. We have the first and are about to commence a second surveillance following on from that. We're looking at things like conflicts of interest, so where there may be transfers and movements and conflicts which can, for example, have problems with valuation. We're then going to be looking at valuations and liquidity. And the reason to look at those things in close focus are we saw some serious concerns in our last year's surveillance. There are also very important things when a market is being tested, which is about what might be going to happen. The other thing we're doing right now is we've just concluded an 8 to 10 week survey going out to, it's about 70 to 80 billion worth of funds under management domestically to see what's being observed here. So we can see whether it's the same or different.
What are some of the key?
We're just pulling that together right now, and we're looking to release. We're going to be, because we think it's time for us to communicate publicly. What did we find? What are we seeing? And how does it relate to the previous findings we've had of concern and where we're going? In the next couple of weeks, we'll be releasing an article that will lay out those early findings. What I would say is, so far, what we have seen is there is a slow but certain creep in some of our concerns, whether it's underwriting conditions, whether it's variability in liquidity across different funds, or whether it's the opacity. For example, and I'll end here. If you look at our original surveillance report, we identified that if you look at 10 or 20 private credit funds, many of them will define default really differently. How that's defined can then trigger whether we have a clear picture or not on whether there are default concerns in Australian private credit. So we've been trying to tease out some of those concerns as well, to circle back to Chair Longo's remarks that we need to be better informed if this is going to continue to grow on what's really happening.
And to become better informed and to reduce some of that opacity, where do we go? Where do we go with that?
What we find in this article, what we find in these surveillance reports, what we said on the record, in November last year about standards, that's what we stand behind. We are working closely with groups like the Financial Services Council, who are really taking a lead for industry in lifting standards. They're quite advanced on those, and I expect it's for them to talk to it, but I expect they'll be releasing something in coming months which will require more consistency in defined terms. Disclosure is one thing, but effective disclosure requires consistency of terms, so default means the same thing, and also a level of transparency around what's held and where.
Yep. Okay, thank you. Thanks, Chair.
Thank you very much. Senator Scarr.
Thank you very much. Can we move on to the Shield Master Fund and First Guardian Master Fund? And can I say, whoever prepared this high-level chronology, thank you very much. There was a lot of work put into that, and I found it extraordinarily helpful.
So for those following along at home, it's Appendix 1 of the submission from ASIC to the committee today, which is a public document.
So it was a very, very helpful document. I want to raise a number of matters mentioned in... Actually, I might just follow on from Senator Whittaker's line of questioning, very helpful questioning, in relation to that report that was done, Mr Kirkland, in relation to GEDZ investing. One of the concerns I have is, and this comes back to something that was mentioned in Chair Longo's opening statement around the enforcement action account, but you're outgunned. So you've got all these influencers, spruikers within Australia, overseas, promoting all sorts of financial products and opportunities, and then you're left to try and combat that with the resources you have. It's like that Sean Connery scene in The Untouchables, right? You brought a knife to a gunfight, right? If people understand that allusion. But what are your comments in relation to that in terms of how we can effectively counter that flood of misinformation, disinformation, targeting people, including young investors? How do we deal with that that issue in terms of how can we effectively combat that misinformation, disinformation?
I would agree it is challenging, Senator. I think just to break it down into a few parts, I think in relation to finfluencers, taking action globally is a key part of it. So the action that I mentioned with other regulators was, I think, the second global week of action in relation to finfluencers, and we were operating with regulators in a number of other jurisdictions, all taking action based on our own regulatory regimes and our own powers. But I think sending that message that finfluencers may be acting anywhere in the world, but we are acting together to try and make sure they comply with the law wherever they are operating is part of the picture. I think in terms of people more broadly, I guess, operating online in Australia and encouraging people to make investments, another part of our response is the work that we do, where it involves scams, our work to take down scam investment websites, which I think we've talked about here before. And then in relation to the conduct that's closer to what's happened with Shield and First Guardian, we've been quite clear about our concern about the actions of what we describe as lead generators. So businesses that often start by advertising on social media, things like free super health checks or super reviews as a way of luring people into handing over their details so that they can then be hit with phone calls that ultimately convince them to switch their super. In that area, we're obviously taking enforcement action, but we do have a view that there are some regulatory gaps, and the government has been consulting recently on a range of proposals that some of which we think would be quite helpful. So it's canvassing, for example, whether there should be a ban on direct communications with consumers about super for a commercial benefit, which would be a way of banning some of that lead generation activity. There are also proposals that would require advertisements in relation to super to online advertisements to contain the AFSL of the entity that's advertising. That would be very helpful as well in terms of us being able to work with the digital platforms to get them to take down ads that aren't coming from an appropriately licensed entity. And there are a range of other proposals as well. But we do think there is a really good reason to be thinking about whether there are regulatory gaps that could be closed.
Okay. If I can go to some particular points in relation to Shield Master Fund and First Guardian, and some concerning articles. I've sort of been following it through the financial media, as I'm sure everyone has, and then the helpful information provided by ASIC has helped me dovetail some of those issues with what ASIC's doing. ASIC is obviously has a formidable focus in relation to this matter, and you go into the detail with respect to that. And I really do commend especially the efforts to reach out to people who may have suffered loss to make sure they're making claims as they should be making claims. I think that's really important. And in fact, before I go on any further, do you have any update with respect to success in that regard?
Yes, we've, I think since the last time we appeared, we've done a lot more. That included quite a lot of media activity last week in particular, where
Do you enjoy that, Mr Kirkland?
Sorry?
Sorry. I asked if you enjoyed that.
Look, it is an interesting question in a way. I mean, I enjoy
there are some radio stations looking for new announcers.
To the extent it means more people complain who might get compensation, then that's very satisfying. But it's pretty sad to be having to communicate about that, which is why I do give quite a considered response to the question. I think, but to answer your question more directly, it's as a result of that activity, we're now up over 3,000 people that have lodged complaints with AFCA that we understand. So earlier this year, when we really started to intensify our efforts, it was just over 2,000, so we have seen an uptick. We understand that as a result of that activity last week, there were people ringing AFCA who had not previously realised they'd been invested in Shield and First Guardian, who are starting that process of making a complaint. We also saw a spike in visits to the Take Your Super Back website, which we funded Super Consumers Australia to provide to assist people to make complaints. So those efforts are having an impact, but obviously with over 11,000 people affected, we've still got a way to go. And so our work is not done, and we just need to continue to be creative in the ways in which we're trying to raise awareness of this, because there are still many people we suspect who don't realise that they're affected, and also trying to make it as easy as possible for them to make a complaint.
Well, and I think we have a role too, senators and MPs have a role too, in terms of our communities trying to bring it to light so that our constituents are actually bringing claims to AFCA.
Senator, can I just, if you don't mind, just leave the chair, just amplify a little bit of what Commissioner Kirkland said, because we have been very focused on trying to make sure that the investors in the Shield and First Guardian master funds are aware of the current situation. As we've given evidence before, we have managed to return some $421 million to investors, and so there may be a number of investors. We may not need 11,000 people to complain to AFCA, but because some of them, well, a large percentage have now had their capital returned. But the point I was just going to make in terms of trying to reach particular investors, that one of the ideas that someone clever in our team had was to do an analysis of the postcodes where the investors reside that have not lodged AFCA complaints. And so in the radio interviews that Commissioner Kirkland's been doing, it's been very helpful to be able to talk specifically about particular suburbs, for example, where we know there are investors residing that haven't lodged AFCA claims yet. So I think that's been very helpful. And the other thing is, I think we're now up to our 12th round of direct mail letters and emails to certain categories of these investors as well. So there is an enormous amount of work, probably unprecedented work, I think, for us in relation to trying to make direct contact with potentially impacted investors.
Can I ask you on notice to provide those postcodes? Would that be possible? Is it
yes,
public?
Yes, of course.
Because I think members and senators would be interested to know, especially whether or not there are postcodes within their own seats.
And indeed, Senator,
hotspots.
Hotspots, yeah.
I may be corrected on this, but I'm fairly sure that we have written to members and senators about the work that we are doing, and I'll find out whether or not that information was included for individuals as well.
I don't remember it being included, but I'd be very interested to know.
Yeah, we can easily provide that information.
Because I'd engage in reach out myself, especially
Indeed.
local media, putting advertisements in or whatever to try and reach those people, because it's absolutely critical, or reach their family members so they can raise it with their parents or grandparents. I want to talk about Interprac Financial, and I was really concerned to see in an article written by Lucas Baird of the Australian Financial Review that they brought an action against AFCA, and they've now added to that action one of the victims of the of this disaster, and that's Melinda Key, and a concern's been raised that this action may delay the the authority of AFCA to process claims which are made to it. And I just want to quote what Melinda said in relation to the impact of this action on her being joined. She said the action, like the one against her, had a real human cost on victims. That was her quote, a real human cost on victims. Behind every complaint number is a person already carrying enormous stress and trauma. Many investors are older Australians who simply do not have the financial or emotional capacity to enjoy years of litigation, end quote. And so this is a person who's lost hundreds of thousands of dollars through these scams, the failure of the funds, and has now been joined by, I understand, an ASIC-listed public company to their action against AFCA. Now, I understand that action's against AFCA, but in the context of the web of actions being taken by ASIC, ASIC have a particular view with respect to that, with respect to how the victim can be supported in particular in relation to this action, the appropriateness of this action. I'd like to give you an opportunity to respond.
Thank you, Senator. Perhaps I'll start, and Mr Savundra or Commissioner Kirkland indeed can add to it. So we're aware of the proceedings that Interprac have taken against AFCA, and they've made a number of allegations against AFCA, including that Interprac's failed to have been afforded procedural fairness. We're also aware, obviously, that Interprac have now joined Ms Key as a party to the proceeding. You know, our view is that's a deeply disappointing approach to be taking to the one of the many victims of the collapse of these funds. One of our concerns, Senator, is that should not act as a disincentive for other investors to lodge AFCA complaints, and we're concerned that it might have, quite understandably, that impact. So we are most concerned, as we were talking about a moment ago, to make sure that any potentially affected investor lodges an AFCA complaint and that people are not put off filing those complaints as a result of the conduct of Interprac in taking these matters. We're also aware now, we've been recently advised by AFCA that Interprac has refused or failed to give effect to the AFCA determination that concerned Ms Key. So that does now put, I think, within our ballpark perhaps the ability to take some action in relation to that failure to give effect to the determination. That's a reasonably recent event, so we are giving that some thought. We also understand that as a result of these actions, AFCA have now announced, I think only yesterday, that AFCA is proposing not to make further determinations at present in relation to Shield and First Guardian complaints lodged against Interprac, but they will, however, continue to receive and accept those complaints. So I think that's important that they still are doing that work. And I think I won't speak for AFCA, but they are doing that really to try to avoid unnecessary complexity and the potential stress for impacted consumers, because clearly they don't want other victims of this to find themselves in the same circumstances as Ms Key. So we are in complete agreement with you, Senator, about that this is a very unfortunate state of events, and I know Commissioner Kirkland and Mr Savundra have engaged with Ms Key on a few occasions and very much understand the personal impact on her.
Well, and I think it's important that Ms Key understands that we on this committee, as members and senators, I'll certainly speak for myself, I'm deeply concerned about the position she's been put in, especially as someone who's been a great advocate for the victims of this financial scandal. And I think it's absolutely outrageous, and I think the directors and shareholders of Interprac need to carefully consider their position with respect to this, because I think it's an appalling state of affairs, absolutely appalling.
Senator, there's one other issue I might just put on the record as well. I don't know if you were going to turn to it in relation to Interprac, and that related to there was a proposed sale of Interprac by Sequoia, which is its head company, and it's a listed company.
For $50,000.
Yes, indeed. And again, we were most concerned about that, and concerned about it because, well, firstly, we didn't understand the transaction and the $50,000, but more importantly, we were concerned that sale might move to deprive victims that we allege, and these are all allegations, I need to be clear, that Interprac was involved in, that it could potentially defeat those claims. So we took immediate action there to try to have receivers appointed to Interprac so we could get to the bottom of the sale and what was going on. And as I understand it at the moment, as a result of that, that sale has been paused, for want of a better word. But I just, want to emphasise and make clear how active ASIC is being in relation to this suite of, complicated and, I must say, heavily defended matters.
Yeah, well, I commend you in relation to that action that was taken. I would love to see the legal advice and structuring advice that was given to Interprac with respect to that proposed sale, and I suspect it would be, I won't speculate, but Diversa.
This is the last one because we were to break at 15:15.
Oh, are we?
Yeah, so if it's going to be quick.
It might not be quick.
Okay. Can we pick that up when we come back?
Sure.
Wonderful. So the committee will now suspend for 1 hour, returning at 2:15? 1:18. Okay, sorry. It's already been a long day. 1:18, 1:20, let's do that. 1:20. I can just indicate that for ASIC, you'll have a little bit longer because the committee will actually have a private meeting to discuss some pressing matters. It shouldn't take too long, and then we'll continue as scheduled. Thank you. The committee will resume. Following the committee meeting, the committee has resolved to hold a public hearing into the KPMG matters on the 19th of June. I also want to, in light of that, developments today and in anticipation of continuing inquiry by yourselves and other regulatory bodies and professional bodies and ourselves, to put on the record that the evidence from the whistleblower was put into the Parliament in the speech that I gave under privilege, and that whistleblower has provided evidence to this committee and is a witness before this committee with all the protections that that offers. And these are the words that describe the protection of the witness. So there should be no action by any party to intimidate in any way, using any method, the whistleblower who has provided such important information for the public good and has been vindicated despite 2 years of attempting to bring this to the attention of a range of entities, including KPMG itself. So this is what we say. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated as a contempt by the Senate. It is also a contempt to give false or misleading evidence. With that said, I'm going to go now. Yes, I'm going to table 2 letters, both the document that was provided to ASIC this morning by KPMG and the document that was provided to the committee. And if you'll indulge me with just one comment on this letter, I'm appreciative of receiving it. I'm sorry that we didn't receive it before we commenced at 9. I don't think that was very good form. And I'm a little concerned by the last part of the letter, which is where it differs from the one that's been received by ASIC, where the letter signed by Martin Shepherd, the chair of KPMG, begins to advise the committee on the way in which we should proceed. Can I be very clear? The committee will follow its own processes, and we expect full cooperation in every way with the requests of the committee for both attendance and the provision of all documents.
And just in that regard, Chair, with indulgence, I just note the powers of the committee to issue subpoenas, and this committee under your chairing has adopted that practice in the past.
Sadly, we've had to, and we will continue in that way in the public good. Thank you very much for your support, Senator Scarr. Ms Whittaker, Senator Whittaker, you have the call.
Thank you, Chair. I'm on this same matter, just hoping to get a better understanding from you about the timeline. So I'll refer firstly to a letter that was tabled earlier this morning by the Chair from Lend Lease, which I understand you have a copy of. And so Senator O'Neill, the Chair, in March 2026, of course, made her statement to the Senate raising the allegations made by the whistleblower. This letter from Lend-Lease to the committee, on the first page at the very bottom, point 3, says, in May 2025, as part of update discussions, representatives from KPMG advised various personnel from Lend-Lease that a whistleblower at KPMG had alleged, etc., etc. My understanding from your earlier evidence is that ASIC commenced an inquiry following the Chair's statement to the Senate on the 24th of March. Is that correct, this year?
It was my evidence that went to the dates, Senator, and it was a little earlier than that. What I understand from our team is that our inquiries commenced on the 14th of April.
14th of April 2026?
Correct.
And do you have... at what point was this matter first brought to ASIC's attention? Your investigations commenced in April 2026, but when was ASIC first made aware of these allegations?
I think, Senator, just looking at the briefing that we've got on the matter, it was following Senator O'Neill's speech to the Senate that raised these allegations.
But how can that be if the investigation was, or the inquiries, sorry, is I think how Ms O'Rourke characterised it, commenced?
In April.
In April, okay, sorry, so it wasn't earlier then?
No, that's right. So
okay.
I think the dates are, just so that we're all, and Mr Savundra will jump in if I've got this wrong, Senator O'Neill delivered her speech on the 24th of March 2026.
Yep.
That came to ASIC's attention. We then commenced a preliminary investigation into allegations about the conduct of a number of registered company auditors at KPMG, and we commenced those inquiries after meeting with KPMG on the 14th of April 2026, and we then received further anonymised information, as Commissioner O'Rourke gave evidence earlier, in writing from KPMG on the 29th of April 2026.
So at no point earlier than Senator O'Neill's statement to the Senate was ASIC aware of these allegations?
You go.
Senator, we had contact at a high level from an individual, but in relation to the detail of that, I'd prefer to provide that evidence in camera.
Okay. Chair, I might seek your advice on that. Perhaps we can consider it at another time.
Can we just suspend for a moment to give consideration to your request? Okay.
I think middle of last year was contact from the whistleblower ascertaining.
The committee will resume, and it is the will of the committee that we will move to an in-camera session for a short period of time to receive evidence of the matter that's been raised by Ms Whittaker. So we'll need to disconnect you, Ms Lawrence, and we'll need to ask people in the public gallery to leave the room until such time as this part of the program is complete, and then you would be, of course, welcome as members of the public to return and see the Parliament at work.
Confirmation from broadcasting.
comprehensive statement of the relevant facts underlying the allegations made by the whistleblower. This will include the new conduct matters we are investigating. Now, I don't believe that is in the letter that they have provided to you at ASIC also this morning. So have KPMG at any point raised with you new conduct matters that they are investigating?
Thank you for your question. We're not sure what that reference to new conduct matters is. So
you don't know.
As of here and now, we don't think so, but we cannot be sure, I'm sorry.
And in a general sense, if a consulting firm becomes aware of misconduct of this nature, would you expect them to bring those concerns to you as the regulator?
Thank you. I think we referred earlier to for the audit partners, so the registered company auditors as opposed to the whole firm or the consultancy aspect of it, that statutory requirement to bring to ASIC's attention misconduct. I think Mr Savandra quoted some of the provisions earlier around those categories of information that are required to be reported to us.
But they have not made a report to you of under those provisions.
We've made, I think in my earlier evidence I did describe the information that KPMG has provided some information to us, so I referred to information being provided to us on the 14th of April and the 29th of April. So yes, there has been provision of some information.
But not prior to that April date? Certainly.
To the best of my knowledge.
No. Okay. Great. That's it from me. Thank you, Chair.
Thank you very much. I'll go to you, Mr. Pulse.
Thank you, and thank you for appearing today. My couple of questions also go to the correspondence that the Senator was referring to with the stuff from KPMG, the Senator O'Neill received on the 29th of May. And in light of the revelations this morning and the changes at KPMG, can I just bring your attention to page 2 in the first paragraph? KPMG has previously reported to professional bodies, regulators and to the committee. Goes on the second sentence, 3 partners have previously been sanctioned regarding this matter. Can I just get a sense of whereabouts are your investigations up to, and are you aware of who the 3 partners are?
Thank you. Yeah, so I think to the earlier discussion around those contacts that we had with KPMG earlier, we did have a meeting with KPMG on the 14th of April around their activities or issues, and then received from them further anonymised information on the 29th of April. I think we gave evidence earlier around that information being anonymised, and the fact we took action to seek the details of the particular people involved under notice.
So you know who they are? Is that public?
We've had those notices.
Sorry, Ms. O'Rourke.
Sorry, forgive me.
Yeah, we know.
We do know who the 3 individuals are.
Do you want to know who they are?
Well, yes.
Is it for public knowledge?
Well, I think I gave evidence before, Mr Booker. Sorry, I'm not sure we've got that information in front of us here, and I think I undertook to take that on notice and provide it to the committee.
That's fine.
Yeah, because I just haven't got it in front of me, I'm afraid.
That's all right. I'm not trying to go down a rabbit hole.
No, indeed.
I'm more trying to understand where your investigations are, because in the next sentence it says, we're continuing to investigate the matter. And so can I ask, when KPMG or a body like this does an investigation, do they do that siloed in their own, or are you part of that investigation, or do you conduct your investigations in parallel? How does the information that they first get in its integrity, how do you know that goes to you, or how do you then come to the similar or an alternative conclusion?
Yeah, it's a very good question, Mr Booker, and to some extent it depends. Like every one of these matters is slightly different, but I can say in relation to this matter, we're aware that KPMG have told us, as you say, that they're conducting their own investigation and that they have determined to sanction 4 individuals. Those are the individuals I don't have the names of in front of me as we're speaking. 3 of those individuals are registered company auditors. and ASIC has jurisdiction in relation to registered company auditors. So we have now commenced our own investigation into those allegations about the conduct of those registered company auditors. So KPMG will do their own investigation, and as we were talking about earlier, companies or partnerships in these circumstances often brief external firms to either do that completely or to work with them and provide advice in relation to them. We will be doing our own investigation alongside that. We would hope that KPMG will divulge to us in full what they find out as a part of their own investigation, so that that can feed into the work that we are doing.
Yep.
And then we will make a decision once we've concluded our work as to whether there are any formal sanctions or enforcement activity that we might wish to take in relation to those 3 registered company auditors.
Excellent, because that then helps me understand some of the following questions I had, where in the next, we also reported a second matter. Will you make a request from KPMG to understand what that second matter is? And they flagged that it was an inappropriate remark in a team setting.
Thank you. Yeah, I think that we've got enough information to understand that that person, who, in relation to that conduct, is not a registered company auditor, and therefore doesn't come within our regulatory oversight. But if we get further information that suggests that there is something that connects to the provisions that we administer, that can be considered further.
So they don't. So you. That falls outside your scope of investigation, but it would fall within our scope.
Yes, indeed.
Yeah.
I mean, this committee can choose to investigate
Yeah.
what it would like to. The only other thing I should say, I think, Mr Bookotz, is that, as I've said a couple of times, this is all emerging almost in real time as we're sitting here today. And so we will be obviously taking away from this committee both the correspondence to the committee, the correspondence to us that we received today as well, and the further broader context, and be working out the various ways in which ASIC may respond. And if the committee is reconvening later in next month, then hopefully we'll be in a position to be more articulate on precisely the various forms of action that we'll be taking.
You are articulate.
Thank you, Senator Scarr.
You're just not able to tell us everything you might be able to tell us. But you're doing it in an articulate way.
Thank you, Senator Scarr. That's most reassuring to me. I don't feel very articulate on some of these answers.
Can I just indicate that your offer to assist the committee would be best, I think, delivered in a written form in the couple of days before our proposed hearing on Friday the 19th of June. So if we could have something from ASIC in writing by the 17th, that would help us, whatever the status of that might be, whether it's in confidence or can, as much as possible, be public to allow, the proper scrutiny in the public place of these matters, which is our goal at all times, only in camera where absolutely necessary.
No, we understand, Senator.
Wonderful. Thank you very much.
In that correspondence, could I just ask you to not only give consideration of what you are investigating, but after our conversations now, what you are unable or what you're not investigating, so that the committee doesn't make assumptions that everything is being investigated, and if you could highlight to us what falls in and outside your purview, so we get a very clear picture of the culture. KPMG, if I can take you to the next page, under the basis of confidentiality, KPMG has sought legal advice in conducting investigations and assessing the results of those investigations, which are ongoing. Can I ask, do they share those legal advices with you as part of your investigations?
Mr Because, as we talked about with the committee earlier, it will obviously be up to KPMG as to the approach it wants to take in this particular matter, but I think it would be fair to say that generally in our experience, when investigations of this sort are undertaken by external law firms, more often than not, they would not be shared with us on the basis of legal professional privilege. And I think that takes us back to the conversation I was having with Senator O'Neill and Senator Scarr earlier. So I don't want to put words in KPMG's mouth in relation to this matter particularly, but our experience is that generally, no, those are not shared with us.
Before you jump on to the next thing, can I just come to a question on that? Because a lot of people listening to this who aren't legal professionals and don't interact with this wouldn't ever have seen the sorts of documents that might exist in a communication between either the chairman of the board or the head of audit or whoever was undertaking the actions on the Office of General Counsel. These are all people who could possibly have a role in discussions around and then the creation of a letter to engage a particular law firm to do something. Now, we're talking about Allens being engaged by KPMG. Could you characterise the nature of such letters in a general way? If you were the Office of General Counsel, what directions and how carefully can the directions be constructed by the Office of General Counsel for KPMG, for example, when they were engaging Allens?
Senator, I think it'd be very hard for me to answer that question in a fair way because it would be speculative. I think there's two important points to make, and I'm probably being repetitive. I think the first point is that we absolutely recognise and respect the right of companies to make proper claims of legal professional privilege, and clearly that has a role to play in enabling people to get free and independent frank and fearless legal advice, and that's very important. So
Absolutely.
I don't want to give any suggestion that we don't respect that right and the importance of that privilege.
I think I could say the committee absolutely accords with that view as well.
Thank you, Senator. And then the second point is the one that we've talked about already today and we've talked about in this committee previously, and that is that in our experience there are claims of legal professional privilege that are made in a very sweeping way, often over a range of materials that we think it is arguable whether or not the full extent of documents can properly have a privileged claim. Those claims are extremely resource intensive to challenge. Ultimately, it's up to a court. If ASIC challenges a privilege claim, it's up to a court to make a determination about the documents in question, but that is a protracted and expensive process. And we have got a practice in ASIC where we try to both protect the privileged nature of claims but enable firms to provide documents to ASIC under what's called a voluntary disclosure agreement. And the reason that we do that is that we think it's a far more efficient and effective way for us to get to the bottom of something very quickly, and that is designed both to get the information that ASIC needs to progress an investigation while at the same time protecting the privilege claims of the firm involved. So we will see where this matter ends up.
Can I go to the more prosaic reality of a letter, though, engaging? So most people know through their experience of driving cars about an engagement with a mechanic. They might not know a lot about what's going on with their car, but they go to the mechanic and they ask them to look under the bonnet. So if we draw an analogy there that we think we've got a problem, we'd like you to look under the bonnet here in KPMG. If you want to find the problem, you say, go and have a look at everything. Find out what's going, why that constant noise is going on in the background. I want you to really find out what's happening. Just go everywhere. I'll give you permission fully to investigate everything. Or perhaps, if I don't want to find what's going on with a car, could I say, I want you to look everywhere in the car, but don't look under the bonnet. Examine the wheels, kick the tyres, have a look around the outside, but do not ask any questions of person A, B, C or D. Is it possible for such a letter to be written? Containing.
Speaking completely hypothetically and not about these particular issues, of course, Senator, that's quite right, that a letter of instructions or engagement to a law firm can put parameters or in any way that the instructing firm wishes to.
Thank you very much. Back to you, Mr Bockholz.
Yeah, thank you. I'm just Are you able to advise this committee at some stage in the future? You know how you just said that you ask for information to be given voluntarily?
Yes.
When you ask KPMG to voluntarily offer their legal advice, can you come back to the committee and just advise whether or not that was offered voluntarily or the request was denied?
Just before you answer, can I confirm that we just got a bip there? Is that you, Miss Lawrence, joining us? No? Miss Lawrence, are you with us?
She might be on mute.
Was that somebody joining or departing? Departing. Okay, thank you very much. In that case, please answer, Ms Court.
Yes, we can advise the committee of that.
That'd be helpful. And in that, our investigations are ongoing, including a separate incident. Now, that separate incident, are you aware of that? And does that issue differ to the question that the Senator asked you about of a new conduct matter in her last line of questioning?
You just might have to show me, take me to the letter, sorry, Mr Booker.
So on the third page, under the basis for confidentiality,
yes,
I think it's probably the third paragraph.
The separate incident?
Yeah, so you know how there's a reference to a separate incident, and then down in Part A there's a new conduct. Are they one and the same, or are they separate? Are they separate from each other?
Yes, no, I understand the question. I can't answer that.
Sure,
I'm afraid,
if you
Mr.
could
Booker.
just take that on notice.
Yes, will do.
Yeah, thanks, Chair.
Thank you very, very much. And I will now go to Ms Jarrett.
Thank you, Chair. I just want to understand the scope of the whistleblower legislation. So we've been talking a lot about KPMG and the allegations that the whistleblowers put forward, but I understand from the Lend-Lease letter that was tabled today that Lend-Lease have said that representatives from KPMG, their auditor, advised various personnel from Lend-Lease that a whistleblower at KPMG had alleged that KPMG had used material from Lend-Lease board papers in tendering for other audits, which was of a physical nature. So, is there under the laws now that you oversee, is there a requirement on Lend-Lease to report to ASIC?
I think we're looking at each other quizzically, which suggests it's a good question that you've asked, Ms Jarrett. I think we think not, but we'd like to take it on notice to be sure of that.
Okay, that would be great. And in considering that, it was May 2025 that Lend-Lease had mentioned in their letter that they had that discussion with KPMG, which was a year prior to.
Yes.
Yep.
KPMG advised you of that?
Chair, we'll double check, but I don't believe so.
What requirements on KPMG are there to advise you?
I don't believe there are any requirements on KPMG, although we would have an expectation that where people see misconduct, we encourage them and expect them to report it to us.
But there's no consequence if they don't?
I'd like to just
double check
that, but I don't believe so.
And if that is the case, and it looks like it may well be the case, is that a critical point of vulnerability of the current system? Oh, sorry.
No,
back to you.
Absolutely fine, Chair. No, please, that's exactly what I was
Mr
going to
Savandra,
ask.
if you can answer, and then back to you for the questioning, Ms Jarrett.
Would it make the system stronger if there was if there is no responsibility on not even a third party, they're an active participant, unfortunately for them, an active victim, to put forward to you as a regulator that something untoward has potentially occurred, allegedly occurred?
At a general level, I think the answer is yes, but the complexity comes in relation to ASIC's jurisdiction, really. So,
and that's the question.
There could be broad concerns within any professional service firm. Again, you need to look at that intersection between what the concern is and ASIC's jurisdiction. So, as Commissioner O'Rourke mentioned earlier, that some of the concerns that are being looked at by KPMG fall outside of our jurisdiction.
It might also be worth, just for the committee's interest, given the nature of the discussion. So there is a Treasury, as I understand it, is in the process of conducting a review of the operation of the whistleblower provision. So that was required in the Corporations Act. So it may be that some of these issues could be properly brought up in the context of that review that Treasury is doing. And then the only other thing that's just, I think, worth drawing the committee's attention to is that ASIC has done a lot of work engaging with companies across the economy in relation to the importance of whistleblower protection. We issued a media release last year calling on Australian companies to adopt better practices to protect whistleblowers. We've done in December last year again, we released a report setting out insights from a whistleblower questionnaire that we had done earlier in the year, where we asked questions of a whole range of companies and what their whistleblower policies and practices were. So there's quite a lot of information that we've already put out based on our sort of survey and surveillance of what's happening out in the corporate world in relation to whistleblower protections that we could provide to you in due course.
Thank you, Chair. So I've just got one further line of questioning on whistleblowers, and then we'll be able to move on to further fields. So can I just indicate that when the whistleblower, frustrated at every point that they try to blow the whistle on the behaviours that are now a matter of public record, came to my office, I was just impressed by the integrity and the personal strength and courage that was manifest in the conversations that went on to get to the point where there was sufficient trust for information to come into my purview and care. And let me say that from the conversations that preceded the delivery of material that was provided to me and then to this committee, it was pretty obvious this was a serious whistleblower, and I think Senator Scarr's already indicated that was our absolute first response. And that is not always the case when we have people put material before us.
We get material from a lot of people.
Yeah, we do, of very varied types. But this was, in my view, from immediately, just as a common sense response, this is somebody who's blowing the whistle on some very egregious behaviours, who'd clearly suffered a bit. Today we have in the statement from the chairman of KPMG, for the first time in writing, a statement says, "I want to take this opportunity through the committee to apologise unreservedly to the whistleblower." To the best of my knowledge, I do believe there was an article in which Mr Tadros quoted KPMG, directly quoted, where they had conveyed to him that the whistleblower was a whistleblower, but that was still not asserted in any written form by KPMG. But in today's letter, this is the first time that they declare the person a whistleblower. Does that in any way impact your assessment of the whistleblower as eligible for whistleblower status or not, that it's now declared by KPMG that the person is now declared as a whistleblower?
I think, Senator, the answer has to remain as Mr Savundra outlined before, the question as to whether or not this potential whistleblower is a question of law, and I'm not sure that the fact that KPMG identifies them as such changes that. I think the important thing is, as we've talked about before, is that we do everything that we can to facilitate the provision of information and to keep that person safe.
Just to tease this out, Chair.
Please.
Sorry, I'm putting a legal hat on. A person can be a whistleblower generally and be generally regarded as a whistleblower, including by KPMG. It's a different question as to whether or not they fit within that cohort of whistleblowers who have the particular protection of the provisions of the Corporations Law. And that's a different question. Perhaps, is that adequate?
It's a far better answer, Senator Scarr. It's what I intended to say. That's quite right.
Yeah.
Two different ways to look at what is a whistleblower.
And this question of status and eligibility to claim status and where that intersects with declarations of speak-up culture, etc.,
Yes.
is a very live matter that really deserves some of the best and brightest minds to resolve in a way that leads to better outcomes in the public place and also better mental health outcomes for people who do have information to share in the public interest, to provide that in a way that is safe for them to do so. Mr Longo, in your view, why are whistleblowers so important to the proper and ethical function of the Australian economy in the general? Why does the Corporations Act have specific laws regarding whistleblowers? And do you have a great interest in the proper treatment of whistleblowers by Australian firms as a cultural practice at ASIC?
I think the answer to that question is yes on all counts.
Yeah.
I think one of the challenges for any regulator is to have access to data or information that leads to action being taken arising out of wrongdoing. And history tells us that from time to time whistleblowers can make an enormous difference to unearthing issues or concerns that but for the whistleblowing would never come to the attention of the authorities. I think Senator Scarr makes an excellent point. We use the word whistleblower in popular parlance in a popular way, but when it comes to protections, that they are clearly legal questions, and whether someone's deemed a whistleblower or not for that purpose is another matter altogether. So we've been spending a lot more time and resources making sure that we're in a good position to accept and assess potential whistleblower information and intelligence. And I think we've made some good progress there, but it's clearly an important part of the system.
And I appreciate that that is the case, Mr Longo. In the long time that I've been a member of and chairing this committee, I've asked questions on behalf of whistleblowers many times, and I do know there's been cultural change under your leadership, and I appreciate that. Clearly there's a little further to go, but I'm sure Ms Court's up for the next phase of the task.
Indeed.
In general then, and it could be yourself, Ms Court, whoever wishes to answer this question, how do most firms handle whistleblowers, and does ASIC expect each corporation to have robust policies and direct lines of reporting about whistleblowers?
Yeah, thank you, Senator. So we, as I mentioned a moment ago, we have a number of publications that are available to companies about what is expected and required of companies, and we've also done, as I mentioned a moment ago, a number of surveillances in relation to particular companies, and we've identified good practice and we've identified problematic practices. So we certainly, there are a range of obligations on particular companies under the Act to have whistleblower policies and procedures, and as I say, we do surveillance of those on a regular basis.
Thank you very much. Mr Longo, I've just indicated that KPMG confirms that
the whistleblower confirms its treatment of a whistleblower and investigations into their allegations fell short of the firm's expectations, those of the whistleblower and the broader community. Do you have a view about what's on the public record with regard to the whistleblower at this point of time and KPMG's interaction with them?
I think it's too early for me to express public views about where this is at. As Deputy Chair, incoming Chair Sarah Court noted a moment ago, it's a fast-moving situation. It's quite remarkable to see KPMG CEO resign today, and I think it's internal head of audit as well.
Yes. Yeah.
So these are quite remarkable developments, and there's clearly something very serious going on that led to such resignation. So I think at this point, all I can really say is that the Commission, as you can see from the evidence that Deputy Chair Court and Chris Savunda and Kate O'Rourke have given, this is getting a lot of attention at ASIC, but it's a fast-moving situation from our perspective.
I think we'd probably all be able to agree, based on what's already public, that there's been a severe mismanagement of the whistleblower process. Is that a fair assessment at this stage?
Yeah. Well, I think given the way things have unfolded, I think observers are entitled to feel some what's going on here sort of feeling. So I think some of particularly in circumstances where there have been a couple of reviews by law firms, it sort of threatens a bit of confidence in, well, you've known about this for a while, you've done some reviews, but you don't seem to have got to the bottom of it. And I think so that seems to be the collective feeling. But as I've indicated, it's now firmly in the sights of this committee, firmly in the sights of ASIC, and we're going to need some time to get to the bottom of what happened here and whether whether the initial reaction or response by KPMG management to what was brought to their attention was adequate. And we're not going to know that until all this additional work's done.
I think there's an admission in here that the process wasn't handled particularly well.
That's an understatement, I think, Chair.
I'm not known for that. Now, with new evidence and expanded scope, Allens are continuing the challenge to challenge the conclusions reached in prior investigations is what is revealed today. What does that mean from your perspective, Mr Longo?
Well, at this stage, I really can't usefully add what I've already said, Chair. There's clearly a lot of unanswered questions, and we're all keen to get answers. And I note that this committee will be reconvening in a few weeks' time, and hopefully that'll give us the time we need to make further inquiries, and hopefully next time round we'll be more expansive as to what's happened here.
Thank you, I appreciate that. If we go to the media release KPMG put out 29th of May, which basically accords with the letters. Nonetheless, I'll just hand those out. They confirm they clearly find deep covenants and cultural issues within, and confirm they've engaged Principia Advisory, a leading global specialist in ethical culture, to undertake an external review of our underlying speak up culture, including the policies and processes that support this. What is the link between a firm's speak up culture and their handling of whistleblowers, to your understanding, Mr Longo?
So could you repeat that question? Tom's just handed me the media
excellent.
Release,
if you
and
want
I was
to
distracted.
Yes, they state that if you've got it in the letter, and then it's also in that release.
Yeah, I've got it right in front of me.
In the letter, it's a paragraph on page 2. It's the 4th from the bottom. In addition.
Okay.
To the ongoing external Allens, which will thoroughly investigate allegations, we've also engaged Principia Advisory, a leading global specialist in ethical culture, to undertake an external review of our underlying speak-up culture, including the policies and processes that support this. And my question is, what's the link between what's called the speak up culture there and whistleblowing?
Well, what I take from this is that in addition to what I would call a more conventional internal investigation, this time led by Allens, there's going to be a broader piece of work, I gather by Principia, that's looking at the culture as a whole and seeing whether there's something about the way that operates. I really can't do more than what's in the document. I think it's an understandable piece of work that they'd want to be doing because the law firm's inquiry is really quite narrow when you think about it. It's what happened here. I suspect the other piece of work is much broader and saying, well, you know, how do we avoid this happening again? But as I really want to stress, I really can't add more than what they've already said publicly. I don't know whether Commissioner O'Rourke...
I was just going to add, Senator, that I think when we did the work reviewing how...
Sorry, can I just get your volume up a little bit because I can't quite hear. Thank you.
Sorry, forgive me. I think our Deputy Chair Court referred to the work we've been doing, surveillance work in relation to the way companies have been meeting their obligations to have, for example, whistleblower programs, reporting processes internally. Those requirements apply under the Corporations Act. So we go back to that question of whether or not they apply to firms that aren't in the Corporations Act. But nonetheless, our understanding is that some of them use the phrase "speak up," like that's a term that's used to describe programs that are in effect those complying with those statutory requirements to have effective policies by which people can whistleblow.
So whistleblowing, fundamental, important in every part of every corporation. It's a big job. You want to get somebody who knows how to do it right. There are many companies, it seems, that think KPMG, or maybe thought KPMG, knew how to do it right. So, you know, frankly, I would assert that the evidence we have at this point of time, and I expect will continue to show, that the speak-up culture was a failure and the whistleblower was in a very precarious position. Nonetheless, can I just draw your attention to a document that should come to you now, and it is the National Australia Bank Whistleblower Protection Policy of April 2026. Can I ask for that to be distributed, please? So I'll just, give the timeline. I think I made my speech on the 24th of March. There are inquiries underway. ASIC is triggered to review its files, figure out what's been going on with a whistleblower. There's correspondence to this committee about denial of any responsibility and assertions that the whistleblower has been treated perfectly with kid gloves. Yet the reality that's emerging is something quite different from the telling of the supposed facts asserted by KPMG. So if you have a look at this policy protection, whistleblower protection policy, April 2026, according to page two of this, if I can take you to that, this is a document that's dealing with the speak-up culture, same language as Mr Yates used when he was giving evidence to this committee with regard to how much better they were than PwC, as I recall. It says, for the NAB Bank's whistleblower protection policy, you can report concerns about wrongdoing to the whistleblower program by contacting the KPMG Fair Call Service. And there's that word again, an independently monitored external hotline and reporting service. Have you heard of KPMG's Fair Call Services?
I don't think any of us have, but any of us at the table have. Whether other ASIC staff may have, not that we're aware of.
Can I just draw your attention to the chart on page 2? Australia, there's a phone number there, and there's an email, faircallnab, completely associated with @kpmg.com.au. They assert in this document to those who use this service through NAB, your identity will be kept strictly confidential and will be only shared if you consent or if the disclosure is to an authorised recipient under law, that is ASIC and APRA, so you get a mention in there. You can be anonymous if you prefer. Are you aware, were you aware that KPMG manages whistleblower reporting for significant firms in Australia for the Australian economy, including one of our biggest banks?
No, we were not aware. Oh, sorry, no one at this table is aware of that.
I am aware that not just the National Australia Bank, but some of the most significant firms in this country seem to be using this service, which gives me pause for concern. Could I ask you to investigate all of the entities that are using this service by KPMG? Who is triaged to fair call KPMG whistleblowing services? What companies are involved? I can say a little bit of digging so far has revealed that the RBA and the ASX actually avail themselves of this whistleblower service, which just blows my mind. And I don't know how long they've been providing that service, but the fact that, you know, the policy approval date is April 26 for NAB just makes me question everything about the authenticity of the mea culpa that is embedded in the document provided to both ASIC and this committee today.
We can certainly make inquiries, someday.
I think I might leave it there. I'm pretty sure that I don't need to ask you if you're concerned.
We're very interested.
It does. Just one follow-up question.
And then we'll go to Ms Lawrence.
Just one follow-up question on that, Chair. It does raise an issue with respect to, and I don't know what the commercial arrangements are between NAB and KPMG. I don't know what other services KPMG may provide NAB. I don't know what the history is, etc. But it does, we talk about the independence of auditors. It does raise a question around the independence of the providers of whistleblowing services. And I know, based on pre-parliamentary experience, there are a number of service providers of whistleblower services. Quite often you need them to be multi-jurisdictional if you've got operations around the world. But it does raise a question as to the prudential probity requirements with respect to the providers of those services, in my mind, as to whether or not relationships between the provider of the services and the company that's engaged them in any way does potentially compromise their independence and they're being seen to be independent. Is that something which ASIC has ever reflected on?
Is O'Rourke?
If we have additional information, we'd be pleased to share it on notice. I think in our review of, like I referred to the fact that way different companies have different arrangements for discharging their responsibilities in relation to whistleblowers, there is variety. Some people do it in-house and have their own arrangements. Others, to your observation, do ask others, or in this case, clearly, to administer their program for them. So I think our answer has been that we've noticed that that's varied, but as to that question of if it is outsourced, there needs to be some sort of independence or not, I'm not sure that's something we've turned our mind to, nor am I aware of any requirements to that end.
Yeah, okay, thank you.
Yeah, it just raises all sorts of questions. If you're entrusted with getting critical information about one of the big four banks, and we've seen the culture in the aired allegations about the free sharing of information, I just wonder how much critical information about, well, whether it's NAB, it's a pretty new contract, there might not be that much there, but if they've been with other major entities in the Australian financial sector, how much inside information for a version of insider trading that's not about money and the stock market, but insider information that enables further business opportunities to be spotted and chased for the pursuit of profit. I have all sorts of questions around that, and again, it just reveals how critically we rely on ethical professional behaviour and perhaps how unobserved some of the opportunities for, to use Mr Kirkland's terms about scamming, we think about it in a very different way, but we don't think that the big entities that are supposed to be doing the auditing are practising potential scamming inside large Australian companies like Lendlease. It's truly shocking to me. I'm going to go now to Ms Lawrence.
Thanks very much, Chair. Appreciate some of these questions you might have addressed in some theme already this morning, but I just, for my purpose, I just wanted to get a little bit more clarity, because today we've heard some really significant announcements around these resignations, but from my view, they can't become the mechanism by which firms are containing their liability while avoiding deeper scrutiny. So I'm just seeking, what assurance can you give the committee that the resignation of senior executives will not narrow the scope of your regulatory scrutiny?
Thank you, Ms Lawrence. So earlier we did describe the scope of our investigations in light of the information we've received to date, and noted that we are making further inquiries and still gathering information. Our investigation is aimed at understanding whether there was any breaches of the duties of the registered company auditors that were, we understand, involved in the conduct that's been described. And that's not the CEO or the head of audit. They are different individuals. And so it is a separate inquiry to that outcome that you've referred to. And, that doesn't affect our investigation of those, or understanding what has happened in relation to those people.
So given now these allegations have entered the public domain, can I just confirm, had you commenced any inquiries prior to this information being public? Any proactive surveillance before KPM's approach to ASIC?
Thank you. We did describe in earlier evidence the dates on which we had received information and commenced our inquiries. So that preliminary investigation did start on the base after the 14th of April, when we received information, after we had a meeting with KPMG, and then, so forgive me, I hope that's of assistance.
And was that then still just ASIC monitoring KPMG, or did an investigation commence?
Yeah, we commenced a preliminary investigation on the 14th of April, 2026.
So do you feel, or not feel, but do you consider there needs to be any reform in where KPMG has, indicated that they'd undertaken a number of internal investigations? So do you see that there needs to be any reform in that process where they're undertaking those investigations in anticipation of regulatory scrutiny?
I think it's Deputy Chair Court here, Ms Lawrence. We've talked about this a little before you joined us today. So one of the issues that we've talked about, I think, in this committee in the past is the nature or the role of ASIC's oversight in relation to these big accounting partnerships, and that our role is in relation to these specific registered company auditor individuals as opposed to the firm overall. In terms of, so that's the sort of the legal position or the legalistic answer. The broader answer is that we certainly engage with these firms on a regular basis, and we would expect them to be letting us know when issues like this arise. In terms of when we first became aware of these issues, the committee earlier went into an in-camera session where we gave all the information that we could give about when these matters first came to our attention.
So, in appreciating it, it's a live matter, but are you able to advise whether you're now taking action to ensure relevant evidence is not altered, destroyed or withheld following these resignations?
We have, as Commissioner O'Rourke noted, we have an investigation underway, and all of our normal investigation procedures therefore apply. We would certainly not be anticipating any alteration of evidence or documents or anything like that, clearly. I mean, that would be well understood by KPMG and those involved.
What protections do you have to make sure it doesn't occur?
Well, there are all sorts of ways that ASIC can obtain information, Senator, from a range of parties that may be involved.
Ms Lawrence.
Thanks. Can you also just how can you assure the committee too that the institutional accountability remains under consideration? Like, what can you speak to there to give us that assurance? So it's not just about any individuals, it's the broader institutional accountability that we want to uphold.
No, I understand that and very much understand the committee's interest in this. One of the other things that we have sort of observed over the course of the day, Ms Lawrence, is that to some extent these matters have been being brought to our attention and arising in the course of the day. So we have undertaken to take the various issues away, including what the information ASIC already has available to it and the new information that's just come to light really in the course of the hearing today. We've undertaken to provide as much information as we can to the committee before the committee convenes on the 19th of June to look at these issues more broadly. So there's a range of different lenses we can look at this, but I'm just a bit loath to speculate too much on where ASIC's jurisdiction lies, but very much understand, obviously, the committee's interest, and we're obviously very interested as well in the information that's been provided to us today.
And I know there was some discussion earlier around legal professional privilege. Can you explain what mechanisms are available to ASIC just to challenge or test some of those privilege claims where that there could be institutional misconduct being alleged?
Yeah, so where a claim of legal professional privilege is made, then it is open to ASIC to contest that. We would be very much encouraging KPMG to provide information to us on a voluntary basis, because that is clearly the most efficient and resource efficient way for ASIC to get to the bottom of the facts here. But ultimately, if we feel that there are legal professional privilege claims that are being made that are too broad or that are not properly based on the provision of legal advice, then we can go to the court and ask a judge to look at the documents and for the judge to make a determination as to whether or not a claim for privilege is validly made. One of the challenges with that for us, though, of course, is that inevitably takes a long time and is resource intensive.
Mm. And just one of the, I guess, the opening line of questioning that the chair had was around this large partnership model and the joint and several liability. And I know in previous hearings we have tried to start to unpack that a bit. Yes. I'm just wondering, in the context of this matter, does this sort of large partnership model effectively avoid any real responsibility on the part of partners? Like, is that an issue we need to be focused on at all in your perspective?
We have talked about these issues, as you say, in this committee previously. I recall it was when we had extensive discussions about PwC at the time. And in our view, and I think we've put this on the record and talked to the committee about it before, we do think there is a gap in the regulatory oversight of large partnership models. So we have jurisdiction in a very limited or confined area. And when I say limited jurisdiction, I mean we don't have any legal powers to make orders or to issue notices and the like to take sanctions in relation to large partnerships. So we engage with them, we use moral suasion, we put out reports about our findings, we have meetings with them, we encourage them to disclose information to us, but ultimately in terms of enforcement actions and outcomes, the imposition of pecuniary penalties, for example, as a result of contravening provisions of the Corporations Act, subject to the issues relating to registered company auditor individuals, we do not have that broader jurisdiction. I think there are some state-based laws that apply to partnerships, but they're not ones that ASIC obviously can administer.
So would a body like the NAC have reach in this respect?
I don't believe so, because I understand the NAC is limited to Commonwealth entities.
Mr. Savandra? Yes, and I think it would only extend to a professional services firm if, in their capacity as a contractor for a Commonwealth or to the Commonwealth. So if they're involved in the work of a Commonwealth agency, to that extent there's a connection, but it'd have to be in respect of an engagement or contract. The conduct would have to be in respect of a contract or an engagement for the Commonwealth.
There may, of course, be broader criminal laws, depending on the nature of the conduct that may apply, and I think I recall it in the PwC matter that was ultimately referred to the AFP for investigation, as I recall. So it's not the case that there are no sanctions available across all laws, it's just that it's not within the Corporations Act, which ASIC administers.
Chair, thanks. I think that's probably a matter I would be interested to pursue some further lines of inquiry, but appreciate my time's probably out for now, and so I'll hand back to you.
Thank you very much, Ms Lawrence. And I think there's one final question from Ms Jarrett on these matters.
There is. I'm just wondering, are you undertaking investigations into the other of the big four for similar behaviour?
I might have to take that on notice, Ms Jarrett.
Okay, thank you.
Can you assist Mr Savandra or Ms O'Rourke?
Ms Jarrett, the only thing that comes to mind is, and we talked earlier in relation to CTM and the audits of CTM, which in response to some questions by PwC. So we're certainly making inquiries in relation to those audits. It won't surprise the committee to know. It's different kind of conduct, obviously. It's really looking at the audit conduct, unlike some of the KPMG allegations that the whistleblower has made or that have been reported, but we are looking at those issues in relation to PwC.
Thank you.
Just to assist the committee, could I ask, do you have any jurisdiction or oversight of independent company directors?
Of company directors?
Yep.
Yes.
Whether they're independent or...
Yes. All company directors are subject to the Corporations Act provisions on directors' duties.
On notice, could you provide us with an indication of the kind of actions you might expect if a whistleblower approached independent directors, which we know was the case with this whistleblower? It's a matter of public record that was undertaken. What is the responsibility incumbent upon those directors then in terms of notifications?
Thank you. We'd be happy to take
and anything else with regard to how that works for the committee to understand. The other thing is we've had a couple of occasions where you've made it very, very clear that there's external audit, and today you've further reinforced that it's company directors of company director auditors
that you oversee.
Registered company
Registered
auditors.
company, sorry, I couldn't find the word.
Yes,
Registered company auditors that you oversee.
Yes.
There is the whole other world that we haven't gone near today, but I think is part of this ecosystem that might have something to do with what's happening on, and that is the internal audit. Could you make it very clear to the committee where responsibility for internal audit lies, and if there's any distinction between the responsibilities of internal auditors and external auditors, for us to make sure we understand the role and scope and
happy to include that.
Reporting lines and responsibilities in that ecosystem, not just as professional observance at a general level, but in the structural, operational way in which that sector is observed as well. That would be helpful. Thank you very much. And to the most patient man in the world of the day, Mr. David Moncrief.
Thank you, Chair.
You have the call.
Thank you. Thank you for appearing today. I just wanted to follow up on a line of questioning from Senator Scarr a few hours ago around the CHESS system, and I think last time, or one of the recent meetings, we did discuss around the capital charge as well, which you did bring up this morning as well. I just wanted to, so it's good to hear that there's been progress on that CHESS process, but have you looked at how effective that capital charge has been, and is there a process for looking at whether that process has been successful in achieving its desired outcomes?
It's too early to say whether it'll deliver the benefits in a timely manner, but it's a critical part of our strategy to incentivise ASX to make the investments required, because until that happens, the capital charge will remain in effect. And that's so I think I mentioned this morning the impact on dividends for shareholders. Until that the investments and the improvements that we've been looking for are achieved, that capital charge will remain in effect. Perhaps Commissioner Constant give a more detailed response.
Thank you. Two parts to your question. I think the first part, sorry, excuse my voice. The first part relates to CHESS, and the CHESS replacement program. So it's worth noting that toward the end of April this year, Release 1 successfully went live. Now ASX are now focused on Release 2. CHESS is a really important part of the refresh and transformation of their capital, of their technology and the capital attached and associated with that. The capital charge, to give some detail on the capital charge, at the moment can confirm ASX is accumulating an additional $150 million above their net tangible asset value. So that net tangible asset value as at the end of last year, 2025 being the baseline, and it will be accumulated in full by 30 June next year. So end of the financial year next year as part of the commitments package. It attaches to much more in a way than CHESS, but CHESS is a really critical part. So it will attach to our being satisfied of the delivery of items associated with the commitments, including the Accelerate plan. And the Accelerate plan and the associated technology strategy are really the key interfaces with CHESS, Release 1, Release 2, and all that needs to happen to position ASX as critical national infrastructure. Your question about the effectiveness of their capital charge, Chair Longo is absolutely right that, to state his words, we're at the beginning of the beginning. Nevertheless, when one of the root causes identified by the panel was shareholder primacy, and that there needed to be consideration by the board of the balance of interests related to critical national infrastructure, not just the return to shareholders. And when we think about the technology transformation that's needed, that Australia needs from the ASX, and that's not just about technological resilience, it's about balance sheet resilience and capital management associated with providing for all that is ahead and giving that sense of balance sheet resilience to support technology resilience and operational resilience. It seems to be a very appropriate and well-matched and well-crafted tool and response to match that root cause and to deal with this transformation period that we have ahead, including the ability of ASIC as the regulator to approve the release at the right point when those range of commitments have been met that do embed that aspiration and that need for resilience and stability. Finally, I would say with respect to the ASIC itself, who have accepted and almost welcomed the report. I think they've used the words welcome. From ASX's perspective, and this may be familiar to you, for entities, whilst a capital charge is an impost and it is a message to shareholders, and it does require a level of keeping capital aside for reinvestment, and it's a proxy for risk drawdown. It also allows ASIC to agree these commitments and the plan, and Chair Longo said we now have the roadmap, and then leave the company to some degree to deal with those issues. Of course, we will keep continually engaged. We're engaging all the time with ASX and holding them to account. But it does give them the space to say, OK, this is the plan, we'll now deliver according to that, and then we will seek the incremental or otherwise release of the capital charge. For what's ahead, again, for ASX and their need to stabilise, transform, refresh, and then be aspirational on critical national infrastructure. Again, it would seem at this point, whilst it's the beginning of the beginning, a very appropriately crafted tool. And at ASIC, we're thinking deeply about how that can be employed and can be attached to, potentially thought about in other operational risk and remediation and frontline supervision challenges.
When you say for those challenges, would that solely be for the ASX, or would that be for other entities regulated by you?
At this stage, thinking about the ASX with respect to those responsibilities, but remaining open-minded, that as we move into this new period, this period we're in right now, where it's not just capital markets are so fundamentally changing, it is of course technology. It is of course technology and the relationship of capital investment into that. We remain open-minded, particularly where we have frontline supervision responsibilities. And you'll be unsurprised again to hear we're thinking about how we look to the success of standards of APRA, for example, CPS 230, and the relationship between CPS 230, operational resilience, but then also ensuring balance sheet and capital resilience in support to support that. So this thinking could be applied more generally depending on what challenges arise.
Thank you. Similar to that, with in relation to that relationship with APRA. You talked in your submission around regulatory submission, regulatory simplification, and talked about the Registry Connect being streamlined over the next 6 months, and the focus for 2027 being digital services for company registrations, if I'm correct. Is that? Do you think that's an ambitious target for regulatory simplification?
Commissioner O'Rourke has done a lot of work in that area to answer that question.
Thank you. We've done a lot of work in regulatory simplification that ranges across many different areas. So we certainly don't have the registry uplift that you described as the sole goal in relation to regulatory simplification. We published in the last couple of weeks a report on the wide range of simplification initiatives that we've undertaken, where we've got to so far, but also had a forward-looking piece as well as what's happening in 2026 and 2027. Having said that, the registry part we think is an important part of those initiatives, because when we did the engagement that formed the basis of our simplification work, we really heard loud and clear that just engaging with us, transacting with us, giving us information, getting information with us could be improved and was very important. It's a day-to-day activity for a lot of Australian businesses and companies, or for people using our data, whether it be for KYC or AML or for just making credit decisions or otherwise. So the registers are used, when I say daily, like every second, every minute, every day. And so having programs to try and improve how they function, that it was made clear to us how important that was. So yes, we've got a focus on registry, and to your point, we're at the moment focused on search. So the work we're doing at the moment is searching the registers, but subject to a bill being passed that you'll be familiar with, that allows us to continue the work, including linking director IDs to companies. Our focus for 2027, from 1 July 2027, will be that step around company registration and lodgement that you referred to.
Yeah, I'll have a look at that report. But is there anything else that you would be looking to work on in this space that you won't require legislative change for? Or
yes. If your question is in relation to simplification overwhelmingly the work that we've just either started or proposed to do is work that we don't need legislation for. Yeah. We started with things that we can do ourselves. Mm-hmm. So web content, regulatory guidance, legislative instruments, roadmaps, all sorts of things that we've identified that we can do to improve addressing complexity, achieving simplification. Overwhelmingly, that is no legislation required. And in relation to the registry, some of the activities under Registry Connect do not need legislative change. So some of the actions in terms of the technology or improving lodgement and indeed registration don't need the legislative change, but for the uplift that we plan, including that linking director ID, we need the legislation. The legislation is also important because it's got, unfortunately, the Act has got an auto commencement provision embedded in it from when the Modernising Business Registers program was live. And on the 1st of July this year, responsibilities for the registers auto commence, they go across to the ATO until that's switched off. So that's kind of a mechanical thing that needs to be addressed. The bill otherwise assists us with powers to the link director ID and companies, as I said, but also allows us to take steps to improve authentication, integrity and performance and user experience. So we're really looking forward to the Senate's consideration of that bill, and if ASIC can assist with any questions, we'd be pleased to do so to resolve any issues.
Great, thank you. In keeping with the theme about the different regulatory bodies, you talked in your submission as well about your work with the ACCC and the NASC around scam prevention. I think it was 185 websites you're removing every week. I wonder if you could discuss a little bit around how that cooperation is going and whether it works well, having all these different entities, all different regulators, all dealing with the same task.
Yeah, thank you, Mr Moncrief. I can answer that. I've been very involved in the work, the scams work that we've been doing with the ACCC and the NASC. I think when the government back in 2022 set up the National Anti-Scam Centre, it really did mark quite a different approach to scams-related work across the economy. And as you'll no doubt be aware, the government decided effectively to bring together the National Anti-Scam Centre. The ACCC is the lead regulator there, but ASIC and the ACMA, the Communications and Media Authority, also play a key role there. So, you know, our observation is it's working very well in the sense that I think before that time there really was sort of responsibility for scams was really spread across a range of different regulators, but there was no particular lead agency responsible for it. The ACCC, I think, has always taken the lead, and they publish every year an annual scams report. It's very important, and sort of updates on how many reports there have been and how much money's been reported, lost and the like. But the NASC has certainly brought that together in a far more coordinated way. One of the things we've been most concerned about, though, is to make sure that we are avoiding duplication and as operating in as coordinated a fashion as we can. And the other I think new feature that the NASC introduced was to recognise that combating and disrupting scams is not just an issue for regulators or for policymakers, for that matter, that we needed to bring industry to the table as well. So that's been done. There's a NASC advisory board that involves a whole range of people, including the regulators and the policymakers, but industry representatives, digital platforms, consumer groups, small business and the like, and that all comes together, chaired by the NASC. I think it's either several times a year, maybe 4 or 5 times a year. Then there is a regulator steering committee that I sit on with the deputy chair of the ACCC and one of the members of the ACMA, and we work together every month to make sure that we're all very coordinated. And then each agency if you like, has a range of its own activities that we are getting on with and making sure that we don't duplicate. So within the ASIC jurisdiction, we focus very much on investment scams. That's our jurisdiction. And we focus a lot on working with the banks. So we've done a lot of deep dives and reporting on the banks and the way that they approach scams. And that has matured a lot, I think it's fair to say, over recent years. And now finally we've got as you'll be well aware, the scams prevention framework, which is, if you like, is formalising the roles of all of those three regulators, and we're looking forward to getting to work under the scams prevention framework when the last pieces come into place. And I think it was just this week that the Assistant Treasurer designated the banks, the telecommunication providers and some of the digital platforms as the first sectors to come under the SPF. So ASIC will have a very active role in relation to those changes.
Great. So does the NASC have? Do you think it has the institutional knowledge to deal with? Do you think you have better institutional knowledge to deal with scams in the financial sector than the NASC?
I don't know that I'd want to say I have do anything better than the NASC in relation to scams. What I would say, though, is ASIC has deep knowledge in relation to the financial sector, and we have deep knowledge in relation to the way that the banks deal with scams. We have responsibility for overseeing the e-payments code, for example, which has a scams adjacent obligation, and ASIC will be under the scams prevention framework. We anticipate the designated regulator to deal with the financial sector and the banks. So I think that builds on our deep knowledge and work with the banks. And I think in practice, as I understand it, while the overarching scams legislation gives powers to the ACCC alone in relation to all sectors, the code-specific obligations for each sector will be distributed between those three regulators. So the ACCC will do digital platforms, ASIC will do banks, the ACMA will do the telecommunications sector. And certainly, I think in practice, we'll be working very closely with the ACCC to make sure that if there is bank-related misconduct that involves scams, I anticipate that at this stage that it will be ASIC that would do any follow-up and enforcement action, given our depth of understanding and work we've already done in that sector.
Yeah, great, thanks. Do you think that, how do we compare internationally on scams? Is it something like, obviously everyone's seen like really high increase in the number of especially telephone scams and online scams. Is that something that we're seeing across the board in similar countries, or is Australia an outlier in any way on this? Are you engaging with your? I mean, I know you engaged with the IOSCO APLC.
IOSCO, that's right.
Do any of these similar issues come up across similar jurisdictions?
I mean, the short answer to that is yes. Scams are a global and multinational problem that regulators around the world are grappling with. I think it may have been before you came into the room, Mr Moncrief, but one of the things that Commissioner Kirkland gave evidence about earlier today was just the importance of regulators working together globally, because unfortunately so many of the scams that Australians fall victim to are online. They come through social media and other posts. The vast majority of those we think come from overseas jurisdictions. Enforcement is challenging in those circumstances. So our sort of primary focus on scams is disruption, and we've introduced a range of things within ASIC to deal with that. I think we've given evidence before. We have a website takedown service that is proved very effective, so that when we get notified as to a scam, we have a global third-party provider that we can provide information to, and they can take that website down very quickly and monitor it to make sure that it doesn't immediately pop back up. We've got an investor alert list where when we know that there are particular entities that we think are fraudulent or scams, we put them onto our investor alert list and we encourage people and direct them to have a look at that. We do some enforcement action as well. And then under the IOSCO banner, there is a big piece of work going on in relation to scams with various jurisdictions working together. And finally, I'd say I think it's fair to say that Australia is seen as ahead of the pack in its regulatory response to scams. It's not something that we've solved. It's going to be a continuing problem. But I think with the introduction of the scams prevention framework and the various obligations that is imposing on each of those three sectors and the proposed compensation and liability provisions in that have been that are policy issues that Treasury are working their way through, and they're hotly contested in some ways. But when those policy positions are landed, that will give consumers some certainty about what their redress options are in relation to scams. At the moment, those redress options, we find there are inconsistent approaches in the ways that the banks deal with complaints about scams.
And so, sorry, I think this will be a short answer. Is that a similar process to what you're seeing internationally? Obviously you're saying Australia's leading the pack, but you're seeing a similar models overseas with conduct financial regulators dealing with these financial scams and having other regulators deal with other parts of the system?
I think it's fair to say that I think the solution that's been proposed here, the multi-sector solution, I think that's unique.
Okay, all right.
And I think the reason for that, as I understand it, is that in other jurisdictions like the UK, I think the liability sits predominantly with financial institutions, and I think the government's idea here was that there are other sectors that are also complicit in scam-related activity, and that it's appropriate for all sectors to bear some responsibility for consumer losses, not just the financial sector, is my understanding of the policy position.
Yeah, cool. All right. Thank you, Chair.
Thank you very much. Senator Scarr, I'll go to you for a 15-minute block, but I just want to indicate that we have missed our afternoon tea break, and that is because Senator Scarr will complete the questioning and then I'll just have a last tiny little bit and we'll depart a little earlier without the afternoon tea break. I thought you might like that.
Thank you, Senator. We do like
that. It's a present, a departing present for you, Mr Longo, Chair Longo.
He might have.
Why you think there'd be any party, Senator?
He might have preferred us to go on till longer.
Yeah, we'll know by the length of the answers. Senator Scarr.
Thank you. If I can go back to the First Guardian and Shield matter, I want to talk about Diversa trustees. So there was an article I saw, the timing's quite interesting, 9 October 2025 by Lucas Baird in the AFR. And I'll just quote from the article. Superannuation group Diversa Trustees has paid its chief executive, Andrew Peterson, an enormous bonus, even after the business exposed thousands of consumers to the First Guardian Master Fund via its wrap platforms and facilitated $250 million of investment into the allegedly fraudulent scheme, end quote. And then the amounts of the bonuses, so this is on top of base remuneration, that it's reported Mr Peterson received were, for the year ending 30 June 2025, $777,000, which gave him total base and STI of $1.7 million for that year. And for the year ending 30 June 2024, he got an STI of $630,000 on top of his base remuneration. And then I note, using your helpful chronology, that in December, barely a few months after that article disclosing these extraordinary amounts of remuneration, ASIC commenced legal proceedings against Diversa. So I want to give you the opportunity, Deputy Chair, to tell us what that legal action is addressed to.
Yeah, thank you, Senator. So, as we've already mentioned, ASIC's had an extensive array of enforcement work arising as a result of the failures of the First Guardian and Shield master funds. Diversa is one of the superannuation trustees who allowed the First Guardian master fund to be on its platform, and retail superannuation investors were able to invest in that fund on the Diversa or through the Diversa trustees platform. We have a fundamental concern that, and as you say, we've taken proceedings in December which are alleging in relation to Diversa that, I mean, in broad layperson's terms, that Diversa should not have allowed the First Guardian Master Fund on its platform. So our allegations are that it failed to conduct adequate due diligence before allowing its members to invest, and that it also failed to conduct ongoing monitoring as to what was going on in relation to that fund. There's a more specific allegation as well that we consider that Diversa had in place a 50% holding limit in relation to investments in the First Guardian Master Fund. Yet we saw, multiple examples of members' funds that were well in excess of that 50%. So another part of our allegation is that it failed to have the systems and processes in place to make sure that that 50% holding limit was complied with. So our allegations are that Diversa, as the superannuation trustee, has a legal duty to put its members first, act with care and skill, and carry out proper checks on the investment options that they make available on their platforms, and we say that they failed in those duties and obligations. We've also, Senator, sought compensation in those proceedings. That's unusual for ASIC. We don't see ourselves generally as a compensation agency. There are other avenues for people to get compensation, but we did think that the circumstances facing the Shield and First Guardian investors really were of such magnitude and of such concern, in the sense that they are all within the regulated superannuation environment, that it was important that we do our best to obtain that compensation. And just to round things out, just in the last week or two, we've also filed proceedings against equity trustees in relation to their what we allege to be failures in making the First Guardian Master Fund available to its superannuation members as well. And with that action against equity trustees, it brings to sort of full to completion. We now have court proceedings against all of the trustees that were involved in relation to these failures. Two of those trustees have admitted the conduct and have resolved matters with ASIC and have paid significant compensation or remediation payments back to their members. Diversa is defending these allegations, as is equity trustees.
So what about quite often in the context of ASIC's enforcement proceedings, you'll bring action against a company. You'll also bring actions against managing directors, say, independent directors, as part of enforcement proceedings. To what extent have proceedings been instituted in the context of Diversa and equity trustees against actual individuals, natural persons?
Yeah, we haven't joined any individuals in those actions, Senator. We did consider it. We did look at the evidence that was available, but ultimately we determined that the evidence supported action against the trustees themselves.
So, Ms Court, you can understand how I'm looking at that article and these huge amounts of bonuses that were paid, some of which may be attributable to financial flows which came back to Diversa as a result of consumers investing in Guardian and Shield. are there any other avenues for clawback of these sorts of bonuses and short-term incentives from executives or corporate officers who had roles with respect to the management of and supervision of these trustees?
Yeah, I think it's a very fair question, Senator. And without wanting to comment on this particular CEO, I think we've talked to this committee before at length about the challenges of individual accountability for particular actions. There are legal tests that have to be fulfilled in relation to hold an individual accountable. We do that where we can, Senator, but in relation to these matters against Diversa and Equity trustees, we made the decision that the most prudent way for us to proceed was to take the action against the responsible entity itself and to focus on trying to get that compensation back for those investors.
Okay. No, I respect the decision. I've got no doubt you would have carefully considered that, but you appreciate the reason I asked the question.
I certainly do.
And then my last question with respect to Diversa, and I've got a few other quick questions in my block, is I then noted an article on the 23rd of March 2026 in relation to Diversa, which mentioned that two of its largest customers had taken concerns to APRA in relation to Diversa's superannuation business, concerned that it was overcharging their members and blocking their efforts to find new trustees for retirement savings. And that raised considerable concern in my mind, because I would have thought, well, you could understand, given what's on the public record and the proceedings which have been instituted in relation to Diversa, I can well understand why some of Diversa's customers may be looking to take that action. I can well understand it. To what extent does ASIC coordinate with APRA in relation to matters like that? So would you expect APRA to be contacting ASIC to consider information as to whether or not the efforts of those customers to seek new trustees shouldn't be blocked?
We have been engaging with APRA very intensely in relation to the whole suite of matters associated with the Shield and First Guardian master funds, and I know that Commissioner Constant and I speak to them regularly, as do our team. So in relation to the particular issue you've raised with me, I haven't personally spoken to APRA about that specifically, but I know our teams will be well aware of it and sharing information as required by APRA.
Ms Constant?
I can confirm that, and including that the sharing of information in regard to some of those client concerns that have been raised also.
Okay. Can I ask you to take on notice that particular issue, because it just concerns me that you've got, on the face of it, customers of Diversa seeking to transition to another trustee, and it appears they're being, to use the words in the article, blocked from doing so. So whatever other information you can provide, and it might well, I think APRA's on next week in terms of Senate estimates, so it might well be a matter I raise with them. And you can tell me in the corridor afterwards if there's anything else I should be asking of APRA. I want to come back to Mr Kirkland's efforts as a putative radio announcer. In terms of advertising, presumably the liquidators of First Guardian and Shield have provided liquidators' reports. Do those reports provide any detail with respect to the funds they spent on marketing? So this comes back to my knife and gun analogy in terms of being outarmed, but is there any indication you've received in relation to how much money that Shield and First Guardian were spending on marketing?
I don't believe I have it. Mr Savandra may be able to answer that question directly.
Senator Scarr, I believe the reports in relation to First Guardian indicate over $40 million on marketing, in large part...
Sorry, over how much?
Over 40 million.
40 million.
Yep, I'll come to Shield shortly. So that was First Guardian, but that's based off information that we've adduced to court in relation to the various proceedings. So I think some caution needs to be exercised around that figure, because when we say it's marketing, it's payments to lead generators and the like. So it depends how you use that term, marketing. In relation to Shield, the figure I believe is somewhere around 65 million.
Goodness me! I mean, these are
lead generators.
So these are the use of the funds spent on lead generators, etc. So these are huge amounts of money that's being dedicated to bringing new customers from using a broader marketing perspective. You'd accept that, Mr. Savundra? These are big numbers?
Absolutely.
And how big's, Chair Longar, how big's your advertising budget?
That's an excellent point. One data point that was brought to my attention today, that a mere $600,000 is being devoted to Money Smart. We don't have an advertising budget.
Okay.
Maybe Scott, our CEO, or someone else at the table can give a bit more detail about how we fund Money Smart's activities.
Mr. Gregson, have you
I
had
can
the
say
opportunity...
to the committee it's an absolute fraction of what was spent
Yep.
luring investors into these matters.
Mr. Gregson,
600,000. Money dumb, 40 million.
have you got, Mr. Gregson? I want to give you an opportunity to put something on Hansard here. Do you have any further figures you can give us or insight?
No, Sarah. I can confirm we don't have an advertising budget in that nature. And yes, if I could put a plug in for Money Smart, I think committees like this could do well to promote its take-up and continue to make sure we're resourced to deliver that. It really is a small amount compared to what you see companies doing.
Senator, just for the sake of completeness, we do have some additional funding this year and in the next few years to do additional advertising in relation to Money Smart's information in relation to super and retirement. But the 600,000 roughly a year is just the normal allocation in a normal year for any Money Smart advertising.
Well, I think Money Smart is an excellent service, and all Australians should go on to Money Smart and make the most of it, and that's written and authorised by Senator Paul Scar. My last question is in relation to prediction markets. So who's the expert on prediction markets?
Well, it depends on your question, Senator.
Well, I'm not asking for tips, but in terms of regulatory issues arising from prediction markets.
You're talking of the emerging trend of the rise of prediction markets overseas.
Correct. So that's you, Ms. Constant?
It's me.
Okay. Well, I'll put these questions to you. Yep. I mean, this has been, as I appreciate it, this is something that's arisen in particular over the last few years. Mm-hmm. So entities like, there's an entity called Polymarket. Is that the Polymarket? Mm-hmm. And you can essentially bet on a whole range of events as to outcomes, whether or not they're going to occur or not. Some of them are extraordinarily bleak and dark. So, for example, as to whether or not forces involved in conflicts will take potential cities by certain times. And I don't even want to really put on the public record some of the things they're actually putting on the market in terms of bets, if I can put it that way. But the issues I'll particularly raise and seek a response as to what ASIC's doing is, firstly, there was a ABC report, very helpful ABC report over the last week or so in relation to these prediction markets. There appears to be hundreds of thousands of Australians who are currently betting or investing or whatever you want to say in relation to these markets. which are based overseas, so presumably not regulated in the Australian context. And secondly, from some of the research I've quickly looked at, and this is an area I'm interested in and you might take on notice, providing further information with respect to a submission before a future hearing. It appears to be, from analysis undertaken, that there's a very small number of account holders who end up getting a very disproportionate amount of the winnings, if I can put it that way, and a very large number of account holders who lose their money, which raises particular concerns in relation to what we would call in a public markets context insider trading. And there are also concerns in relation to the compromising of national security, even national security information, because there's a financial inducement to perhaps access that information in order to participate in these markets. So there are very many layers to this. So very interested to hear what ASIC is doing in this regard. And how you're dealing with that conundrum which we face in a number of areas of do we regulate some way in order to try and militate against mitigate against risks, or do we just keep out of it and we've got hundreds of thousands of Australians doing their dough in relation to these unregulated markets?
Thank you, Senator Scarr. I think you've invited us to talk at this point in time about our perspective on these prediction markets. So it might be worth, contrary to what I often do, it might be worth my reading to you from some of the considerations we've been making, because it's quite live and active at ASIC at the moment.
Okay, yep.
So, because it was quite rich, your introduction question. And the way we've been thinking about this and considering it is consistent, I think, with the tone and even some of your content. So to confirm, we would agree that we've seen prediction markets have expanded rapidly. That's partly technological, it's partly, as you say, overseas regulatory developments. And whilst they were a small, unusual category of these markets until recent years, there's now, as you mentioned, a whole wide new range of categories, for example, that introduce a whole wide range of new risks that have given rise to the rise in trading volume in these globally, but also absolutely the risk. And you called out some there that are just quite dark to consider in nature. So not just this kind of simple binary outcome and, as you say, the lack of winnings that seem to flow through. So what we would say at the moment is we've noted this, and it's not that this is not regulated or licensed, elements of licensing that aren't relevant in the Australian context already. So we would say that generally this does not sound to be consistent with public interest, would be the first statement, consistent with your introductory remarks. We're considering appropriate interventions for those limited entities that may already be licensed if there is behaviour that requires us to intervene. But generally, given that comment, your comments, consistent with our view on the public interest here, ASIC at this stage, it's unlikely to be granting licences to offer these products in Australia. So I think we're also thinking about more general positioning with regard to our tone and comment on the rise of these markets, and including, as you mentioned, Australians participating through those entities, overseas entities that we don't regulate and cannot control.
Okay, well, it's an area I'm interested in. I'll perhaps pursue at our next hearing.
I suspect, Senator Scarr, that will be excellent timing for when we've done more work and thought about our public messaging, and also considered whether the rise here and had a look at those limited entities that may have an element of licence to offer this at the moment, how that is being used. That will be excellent timing. It's not lost on us the accelerating take-up of these prediction markets.
Okay, thank you. Thanks, Chair.
Thank you very much. Fast and accelerating. I was going to ask questions about the SpaceX listing that's supposed to be pretty fast and accelerating technology. I think there were questions also from Ms Jarrett that we were thinking about asking with regard to AI and cyber security, etc. But I think we've we'll leave those for discussion on another day. If there's anything important that you think we should know about either of those matters, I trust you'll let us know. I want to conclude with...
Chair, I would just mention on the Frontier AI, I just reference a letter that we wrote, an open letter in recent weeks under my name to entities. So perhaps for next time that might be a good starting point for discussion. Great. And how we've seen entities respond or not to that.
Well, Ms Jarrett won't let you get away without that now, so she's interested and you've made a commitment, so I expect that will be definitely a matter of discussion at our next meeting. I just want to indicate I came across a document. I don't ask you to read it, but it's KPMG's Top Risks to Australian Businesses 2024-25. And on page 3, it asserts, with regards to matters of trust and reputation, declining trust in public institutions and leaders is translating into increased expectations of businesses. Because growth requires trust, companies will need to work harder to build and maintain the public's trusts by ensuring transparency, demonstrating ethical conduct, and taking responsibility for the conduct of suppliers further up the supply chain than ever before. The challenge will be in ensuring that building trust with one section of the community does not undermine trust elsewhere. It's hard to read that in the light of what's happened today and the experience of the whistleblower over the entire period in which this must be put together. So I wanted to just make a couple of concluding observations and give you an opportunity to comment. You indicated in your opening statement, Mr Longo, a significant increase in a range of enforcement activities, court outcomes, and these are all in the document that you've given to me. In one of them, in not one of them, can I see any statements about auditors? Are there any auditors who've suffered major financial blows or been excluded from continuing in the sector?
I'm not aware of any particular auditors being excluded, Commissioner O'Rourke.
Thank you. So thank you for your question. So in the summary that was included for this morning and to outline ahead of that, there was a selection of matters, but certainly not a full representation of all of the outcomes or current actions that are being taken in relation to in our enforcement.
Could you, on notice then, just give us an exclusive list of, auditors?
Sure.
And the degree of sanction? Because clearly something's not working if the cultures that are being revealed here continue to just be discovered by this committee following extraordinary efforts by whistleblowers. There's got to be something better done to prevent egregious behaviour of this kind in these major auditing companies.
We'll take
Ms.
that on notice.
Ms. Court, yes?
Yes, Senator O'Neill. We'll take that on notice, but we do have a range of enforcement-related activity in relation to enforcement. In fact, we've taken our federal court proceedings in December suing BDO Audit and its director, Mr Just, alleging materially false or misleading audit reports. There's been multiple cancellations of by the CADB of auditor registrations. So I'll take it on notice, but I just want to assure you that has been an enforcement priority in 2026, and we have a range of things that we can talk to you about when we have more time about the work that we've been doing there.
And maybe a bit of an update on how many referrals to the CADB, because there was a period of time where that wasn't occurring, and I'm not sure if that's changed in any way.
I can tell you, Senator, sorry to interrupt you, we currently have 36 open matters underway at the moment in relation to auditor investigations. 16 of those are preliminary inquiries and 20 of those are current investigations.
Okay. If I look at the Macquarie Securities information that you've got here, you said that MSAL failed to correctly report at least $73 million short sales between 11 December 2009 and February 14, 2024. ASIC estimating 298 million to 1.5 billion short sales may have been misreported due to significant deficiencies in systems, processes and controls over more than a decade. The civil penalty to that matter was a $35 million civil penalty. I don't know how that could have occurred without significant engagement at some points of auditors. How are the auditors who were involved in, who was auditing Macquarie at that time? What was going on there? What's your action to the auditors who were involved with the reporting of MSAL, Macquarie Securities Australia Limited, between December 2009 and 2024, and what action or investigation was undertaken with regard to failures of audit, which are retrospectively, I think, likely to have been occurring?
I think we might take that on notice if that's all right.
Thank you.
Senator, I don't have that information in front of me.
And finally, one of the things I've been trying to say, and I've just found these wonderful words from you that I think say it most succinctly, my concerns about investors, sophisticated and unsophisticated, old, young, SMSFs, trustees, retail, industry, everybody who's engaged in the Australian Stock Exchange or in the trading of financial products. This is what you said with regard to urban ecological systems. It's a public company. You said each company is required by law to provide financial reports to ASIC and report to its members, among other obligations. You said these reporting requirements, which are absolutely intimately connected with audit, these reporting requirements are in place to help shareholders and those dealing with these businesses to make informed decisions and support the integrity of Australia's financial system. Well, today I think we've seen real threats to that have led to the resignation of the CEO of one of the biggest audit companies that services Australia's financial system. And I'm sure that, like me, you are appalled. That is one thing, but we need to have incredible action in response to this. It's an opportunity to not just send a message, but to make sure it's delivered, received, and that change occurs. I want to acknowledge in this the Fourth Estate, in this matter of the KPMG, how critical they have been in following up, checking their sources, and in addition to the whistleblower who's contacted us and is likely to be the one who might have contacted you and certainly the one who contacted KPMG, there are other whistleblowers now finding courage to come forward as well to verify some of the things that were unable to be found by KPMG itself. I also want to particularly acknowledge Mr Ed Tadros for his dedication to the task.
Sorry, Chair, just to clarify, you said uncovering some of the things that were unable to be uncovered by KPMG. That's still very much in question, isn't it?
It is, yeah.
Sorry to interrupt.
No, it's true. At this point of time, unable to, they didn't find the resources to find what was there before their eyes. But Mr Tadros, I think, deserves particular recognition for his service to the Australian people through proper reporting. And also, I note in recent days, Ms Tansey Court in the Court, in the Australian. So the Australian Financial Review and the Australian have been covering this matter quite significantly. So I want to acknowledge that. And can I encourage you to communicate with both those people, because clearly they have trust with some of the participants, and I expect that they would be able, within the boundaries of their professional responsibilities, to assist you further too.
And Senator O'Neill, before you leave the topic of KPMG, can I just put one other thing on the record? It just flows from the conversation this morning and your request to be told when ASIC had been contacted about the events of today. So it's just come to our attention in the last little while since that we did get an email from KPMG at 5:33 yesterday evening letting us know that there would be an update that KPMG expects to announce tomorrow morning. So this morning, in response to the whistleblower allegations, the relevant decisions are currently being finalised. We also intend to write formally to ASIC tomorrow and will offer to provide an in-person briefing. We understand you're before the committee tomorrow, so please reach out if you would like to discuss. So we got that yesterday evening. I wasn't aware of that when we spoke earlier, so I just wanted to put that on the record, Senator.
I don't believe that this committee has got any such communication.
Not that we're aware of. We'll double check that. But
we certainly had no details, but just the fact that there would be the announcement today.
Yeah, thank you very much for the fullness of the response and clarification there. Can I thank all of the commissioners for your ongoing work, for your attendance here today, for your frank and honest answers to the questions that we've asked you today. Can I thank my fellow senators and members of the Australian Parliament, Mr Moncrieff, Ms Jarrett, Senator Whittaker, Ms Lawrence, Mr Buchholz and Senator Scarr. Thank you for your attendance and your curiosity about matters of importance to the Australian people. Also, can I thank very much the Secretariat for their hard work in preparing this, and I want to also thank my fantastic staff for their hard work. I really appreciate their support in bringing materials here well prepared. That concludes today's hearing. The committee is adjourned.
Thank you.
Thank you.
Thanks very much.